Tracy Shaw for wrongful eviction and an assault.
Court come to order. All rise.
Be seated, please.
Kevin.
Case 2097, Duran versus Shaw.
Thank you.
You're welcome.
Ms. Duran, the defendant is the property manager at a place where you used to live.
Yes.
And you are suing her for evicting you from that place. You want a whole bunch of money. You're suing her for $10,000 for your moving expenses, for assault, for emotional distress because you had to move. Ms. Shaw says that your behavior caused you to be evicted. You violated the rules, and that's why you were served notice of eviction. So first, let me know when you started living at the property that is managed by the defendant.
In 2019.
Did you have a lease?
Yes, I did.
Do you have a copy of that lease with you?
Yes, I do.
I'd like to take a look at it.
Melissa produces a document, then hands it to Kevin. He brings it to Judy, who reviews it.
Okay, so this initial lease was August of 2019, and it terminated on July 31st, 2020. It provided for 3 people to live in the apartment. Okay, and was the lease renewed?
Nope.
Okay, and so then you became a month-to-month tenant?
Yes.
And that was in February of 2020?
They also increased the rent.
That's okay, they're allowed to do that. That's a business.
No, I know.
They're allowed to do that. When your lease was extended on a month-to-month basis after February of 2020, would you tell me if the same people lived in the apartment as were on the original lease?
No.
So more people moved in?
Yes.
Who?
That would be my sisters and my mother.
Sisters?
Yes.
2 sisters?
Yes.
And when did they move in?
Maybe about, maybe 2020, maybe? Couldn't really be positive.
So that would have been in violation of your original lease?
Yes.
And it was an apartment that you were
Yes.
renting? And the apartment complex has a pool?
Yes, it does.
And the incident around, circumstances surrounding this eviction that was served on you, that happened in what month and year?
It was in June of this year.
How long, Ms. Shaw, have you been the property manager?
Since the end of November of last year.
November of 2021?
Yes.
And in November of 2021, did you know that there were additional people living in the house?
Yes.
And didn't tell her that they had to vacate, that it was in violation of the terms of her underlying lease?
I had that morning, actually, when the confrontation happened.
No,
I
I'm
had
talking
just-
about, pay attention. My question was, did you register any complaint with the plaintiff about the additional people living there? Be very careful that you tell me the truth, because I know that you think you may know where I'm going, but you don't. Did you make any complaint to her November, December, January, February, March, April, or May? The answer is either yes or no about the other people living in the house.
No.
So I guess I'm going to start with you, because an incident occurred that resulted in her being evicted, that you're serving her with a notice of eviction.
Right.
Tell me when that took place, because I have to know what your reason was. That's a fair statement.
Yes.
Right.
Okay.
So in June 22, like I said, that morning I had served them.
What
that
morning?
June 21st or something, I believe.
What kind of letter were you serving on her?
I just gave them, mine is, it's just a complaint notice, you know, saying that.
Do you have a copy of that? Do you know what she's talking about?
Yes, I have a copy.
I'd like to see it.
There you go.
Melissa produces a document. Kevin collects it, then brings it to Judy, who reviews it.
Okay, well, this is a letter that says you and your company were eating and drinking in the pool area even after I told them to stop, that it wasn't allowed. They did not stop, and there is absolutely no eating or drinking in the pool area. Okay, so that's the letter she
Yes.
served to you, and that was on June 21st.
That's the letter she
Now,
threw
who
at
was
me.
eating and drinking in the pool?
That would be my sister.
That wasn't just your sister.
No, it was her and her
No,
friend.
no, just a second. Let's get it together. So your sister, who wasn't supposed to be there, but they sort of let that skate.
Oh,
Who
well,
wasn't supposed to be there.
Okay.
Okay, so your sister and who else?
That would be my sister, her boyfriend, and 2 of her friends, or 3 of her friends, I think.
Had they ever been to the pool before?
My sister has, but not her friends.
So the person who wasn't supposed to be living with you, that's your sister,
Yes.
invited her boyfriend and 3 other friends to the pool.
She called and asked if it was okay first.
She asked you.
Yes.
And you said fine.
Yes.
You didn't call the manager.
No.
Okay. And you are aware that there's no eating and drinking in the pool.
That's not what it says on my lease.
Is that what it says at the pool?
Nope.
Does it say anywhere in the house rules?
Nope.
Nope, it's not an answer.
Oh, I'm sorry.
The answer is no.
No, ma'am, it is not.
No. Now, when you've been living there for a long time, do you use the pool?
Yes, I do.
Ever had any trouble in the time from November of last year? Ever had any complaint?
Nope.
Nope is
No,
not an
sorry,
answer.
sorry,
No
I'm
is
sorry.
the answer. No,
Yeah,
no
okay,
complaint.
no, sorry.
Okay. And did you discuss with your sister and her friends that there were any rules that she had to abide by?
No, I did not, because I was not home yet.
Stand up.
Melissa's sister rises.
First name is?
Aaliyah.
You were their boyfriend and 3 girlfriends. Any children?
No.
You know this lady?
Yes.
What happened when she came to tell you that there was no eating or drinking at the pool?
So we were standing.
Just what happened when she told
She
you?
came screaming at us, telling us that we needed to get the food out and that we needed to go.
Get the food out. What kind of food had you
It was
brought
just
in?
pizza and like a soda and water.
So it wasn't a piece of fruit. You were having a meal there, pizza
Yes.
and food. Had you ever seen your sister bring food into the pool area?
Snacks, yeah.
Yeah. I'm not talking about snacks. Did she ever bring food into the pool area?
No.
What prompted you to order food into the pool area?
It was a hot day and we were hungry and I'm not sure.
You asked your sister if it was okay if you and your friends came.
Yes.
Since you never saw anybody, because usually there are signs posted
Yeah.
around a pool. I've lived in enough places to know, and the pool signs usually say no jumping in the pool, no food or drink around the pool, right?
Yes.
Most pools say that.
Yes.
Did this pool say that?
It just said, like you said, no jumping in the pool, no diving, to come into the pool, but it never said nothing about food, drinks, nothing like that.
Really?
Yes.
Okay, so now you please establish to me, Miss Shaw, that there was notice that there was no food and drink at the pool.
Their pool addendum,
May I see?
Tracy hands a document to Kevin, who brings it to Judy.
and then also no guest addendum.
Just a second.
It's all part of their.
Hold on. You're Melissa Duran,
Yes, I am.
and that's your signature?
Yes.
Yes. The pool is reserved exclusively for the use of residents of the building. That's what it says.
Okay.
That's what you signed. No diving in the pool area, no intoxicated persons. Okay, I just want you to show me here, first of all, the only thing that they are violating is that pool is reserved exclusively for the residents of the building. That's in here, but I don't see anything about food.
The new pool addendum wasn't part of their contract. So when we put out the new one, it was for more updated tenants, but we didn't
Just a
serve
second.
them on the
Hers-
food, we served them on the guests.
Is what you're saying to me, the only thing that she signed is this, and there is no sign around the pool that says no eating or drinking.
There is a sign by the pool.
Do you have a copy
I
of it?
don't have a copy of that.
Why not?
Caption, coming up.
I texted her that I was sorry that they had food in the pool, and I did not know that.
So that you knew they weren't supposed to have food in the pool.
Yeah, but I didn't know they bring it. The thing.
Just a second. That's not what I asked you.
A courthouse. The Judy Justice logo appears. In the courtroom, Melissa and Tracy.
Melissa Duran claims her former property manager, Tracy Shaw, owes for a wrongful eviction and an assault.
Okay, go ahead.
Because she had moved in prior to them changing the pool addendum, I posted the new pool addendum on all of the doors. And I have actually text messages of Melissa asking me, can we, the no floaties? And I said, well, of course,
May I?
For
Oh.
children and whatnot, but not big floaties.
Okay.
So she was acknowledging the pool addendum that I had.
That I'll see. Now, she's going to show me your text messages to her.
Yes.
So you received the revised pool rules.
Yes.
And did the new pool rules say anything about guests?
No, it did not.
So if it said nothing about guests, you originally said that the pool is specifically reserved for residents of the complex.
Yes.
And according to you, the new pool rules, do they talk about having floaties in the pool?
Yes, it did.
Did it talk about having guests at the pool?
Yeah, actually it did.
And what did it say?
There was no problem, just like on the original lease. It was
No.
fine to have guests in the pool.
No, that's not what this says. This says that the pool is reserved for residents of the building only.
Well, we were already told before that it was fine to have guests.
This is the contract that you signed.
Yes, I
Okay?
understand.
So this is the first one that you signed, this one. And absent anything else, this says no guests at the pool. This says residents only.
Okay.
You say that it was the new rules allow you to have guests, or were they silent?
There was nothing on there saying that you cannot have guests. It was mainly just saying that you cannot have floaties, you cannot jump or run into the pool.
Just a second. Did it say anything about food?
No.
Is there a new sign posted around the pool that talks about food?
No, it does
All I
not.
want to see is, Miss Shaw,
Right.
something in the new rules that talks about food. And I'm getting very bored with this. Now, when Miss Shaw came over and told you you couldn't have food, you had to get rid of the food, about what time was that?
Probably like 5, 6. I'm not exactly too sure.
And when had this food and stuff arrived? Was it?
We brought it. We were coming in with the food. We walked in with the food. I'm pretty sure
Just a
she's seen
second.
us.
So you and your group, 5 people, walked
Yes.
in with dinner
Yes.
to the pool area. And did the dinner include any alcoholic beverages
No.
like beer?
Nope.
What kind of drinks were there?
It was Pepsi. It was soda.
And what happened when Miss Shaw came over and told you you weren't allowed to have the food at the pool?
She came very aggressively.
Okay, she came aggressively and she said you're not
stormed
allowed.
out and screamed, get the food out, and you guys need to leave.
And so what did you do?
I told her, okay, I'd get the food out, and I made a call to my sister to come help me with the food. And as we were packaging
Where was your
it-
sister?
She was upstairs.
So when you came out with the food, you came out of the apartment.
No, we had just gotten there. We were coming from another pool area that wasn't
What other
open.
pool area?
My boyfriend's friend. We were gonna swim at his pool, but it wasn't available because there was too many people there.
Were you at your boyfriend's house during the day?
No, I was at school, and they were all at work, so we all just like met up after everything.
Okay, so you were asked by Miss Shaw to get the food out, and then you called your sister.
Yes, and I told her.
And then what happened?
And I told her if she could come get the food while we swam, or if not, that we
Why
were gonna
didn't
leave.
you just get out?
Well, because I was trying to help, because we were splitting the check through it, the money, so we're like splitting the pizza, who's getting what, and all of that. And before we even could leave, she stormed out again, screaming, saying, you guys are getting a notice, you guys are getting a notice, and running up the stairs to her, because she was coming out. And she was like, hey, like, what's going on? And then she was like, you guys are getting a notice. I'm tired of everybody like not listening and coming to me with your problems. And then my sister was like, whoa, like, hey, like, relax. I'm coming to get the food. And then she threw the paper and my sister backed up like,
Okay,
'cause she, like,
so
went
the
aggressive.
letter, she gave your sister the letter.
It was a notice.
She gave you the paper that said, this is a complaint. There are people in the pool who are eating, drinking. They don't belong here. They're not, whatever. She said, here's your notice.
Yes.
Okay, and that was on the 21st of June. Then what happened?
Well, after she threw the paper at me, she turned back around, still yelling, and she stomped down the stairs, and I'm trying to tell her, you didn't give me time to come and get the food. And she ran back in her apartment and slammed her door.
And she went back to her apartment, and you went where?
Back into my house.
Okay, you went back into your house. And what
Yes.
did you do when you went back into your house?
When I got back there, I texted her, telling her that I was sorry that they had food in the pool, and I did not know that because I did not know at the time.
Just a second. So, Ms. Duran, let's cut to the chase, so that you knew they weren't supposed to have food in the pool, only snacks.
Yeah, but I didn't know they bring it. That's the thing.
Just a second. That's not what I asked you.
Okay, I'm sorry.
You knew that there was no food in the pool, only water and snacks.
Okay, yes.
So you knew that.
Okay, yes.
Okay. Now, if you know that, and you have given, I'm just telling you what the law is. If you know that there is a rule, and you don't convey that, that's your problem, okay?
Okay.
All right, so that's June 21st, when guests that you agreed to have in the pool, you didn't know that there was food there. You knew that there wasn't supposed to be food there. That knowledge is imparted to your guests. That's a legal assumption. I want to know what happened after June 21st. When were you served with a 3-day notice to quit?
I believe it was on the 24th.
I'd like to see it.
Okay. I have 3 of the same. They sent me 3 of them.
I just have to see one. Did the attorney, who you say you gave by a cash app, return any of the money? Okay, well, you served this 3-day notice to quit, Ms. Shaw, and in it, you are alleging threatens to commit a crime. So I assume that the person, it talks about a statement, threatens to commit a crime. I assume that the threat was directed to you.
Yes.
In any event, you were given a 3-day notice to quit, but actually you managed to get that extended to 30 days.
Yes.
And one of the things that you had to do was to hire an attorney.
Yes.
And when you hired an attorney, did you hire an attorney and pay a retainer?
Oh, yes, I did.
Okay. I'd like to see proof of what you paid the attorney.
I don't think I bring the one that pertained to the lawyer. What I do have is him finding out what the criminal act was.
No. You're a month-to-month tenant.
Yes.
Landlord has a right to give you a 30-day notice and say you have to quit the premises. You have no legal right to be there. My only question is you were not given 30 days notice. You were given a 3-day notice, and I'm not actually convinced that there was a basis to give you a 3-day notice.
Caption coming up.
If I called him, would he tell me that you paid him
Yes.
$1,200?
Yes, he would. Though I still owe him $250.
So you paid him $950.
Okay, okay.
What do you mean, okay?
A courthouse. The Judy Justice logo appears. In the courtroom, Melissa and Tracy.
Melissa Duran has accused her former property manager, Tracy Shaw, of wrongfully evicting her. Tracy claims Melissa was violating apartment rules.
Now, if you got 30 days, and the reason you got 30 days is because you retained an attorney, I'm prepared to look to see how much you paid the attorney, because that's an expense that you have that you wouldn't have had but for the 3-day notice to quit. They're entitled to tell you to leave. I mean,
Yeah.
you're there with too many people living in the apartment. They've already had a kerfuffle because you allowed your sister and her boyfriend and friends to come to the pool. They were told no food. They ignored them. But I don't think any of that rises to the level of grounds to give you a 3-day notice to quit. I think that if they want to tell you that you have to be out in 30 days, that's reasonable, but they didn't. They gave you a 3-day notice forcing you to hire an attorney. I'm prepared to give you the attorney's fees if you prove to me that you paid an attorney.
I do have proof of that, but I do not have it with me.
Okay. And how much did you pay him? That's an easy thing for me to verify.
I believe it was
No.
$1,200.
I want you to think about it
No,
carefully.
it was $1,200 because he had lowered it. He lowered it from $1,400 to $1,200.
And you paid him by check or cash?
I paid him in Cash App is the only way I could.
Did he go to court with you?
We haven't, this is the first court we have been to.
So how did he get you 30 days?
Because I got the 3-day notice and it kept saying I committed a criminal act.
Okay, let's...
So that was the reason why I obtained the lawyer, so he can find out what the criminal act was.
And just by phone calls, he got them to extend it to 30 days. So
Yes.
you were never in... And you left after the 30 days.
I left before the 30, I left on August 1st.
Okay. And where did you go?
I had to move all the way to Atwater, California.
Is that where you live now?
Yes, it is.
And who lives with you?
My husband and my young son, that's it, just the 3 of us. We moved into a smaller, more expensive place.
Okay. And you left your sisters
And my mother,
and your mother.
they are somewhere completely different.
Okay. What do you...
This is in their lease about disturbances and threats.
Listen, I've already made a determination that the 3-day notice should have been a 30-day notice to leave. I don't think that anything that I've heard today rises to the level of giving people who've been in the apartment as long as they had, especially over pizza, requires a 3-day notice. So the only question that I'm entertaining on behalf of the plaintiff and the only monetary award that I'm going to contemplate are attorney's fees. Did the attorney, who you say you gave by a Cash App, return any of the money since he never had to go to court for you?
No, he did not.
Just a second. If I called him right now, would he tell me that you paid him
Yes.
$1,200?
Yes, he would. Yes, he would. Though what I was going to tell you is that I did not have enough to pay him completely. I still owe him $250.
So you didn't pay him. So you paid him $950.
Okay, okay. I'm sorry.
What do you mean,
I
okay?
didn't- No, I mean, I'm sorry, I didn't.
So you paid him $950.
Yes.
I'm awarding you $950, which are your attorney's fees, for the reason that, I'm speaking, for the reasons that I've stated, because they have an absolute right to give you a 30-day notice tell you to leave. And there was a basis for it, actually. And you know, there was a basis for saying your guests, which is you, are not abiding by the rules. You're a month-to-month tenant. Right now, we do not intend to keep you as a tenant. We're giving you 30 days notice to find another place. I think that would have been absolutely a problem. Speaking would have been absolutely appropriate. I think a 3-day notice to quit was inappropriate given the level of infraction. So I'm awarding you the counsel fees because that's what it took to get you your 30 days. This case is over. Thank you very much.
Thank you.
This court is adjourned.
Tracy.
I'm disappointed in the decision.
Her actions of her aggression, throwing something in my face, that was a little bit excessive.
I don't feel that I got to say more of the story that continued to happen.
Her actions caused me to get evicted in 3 days.
They have bad character, and so I don't think that I owe them anything.
I mean, I didn't think anything like would come to this, you know.
I'm just glad they're gone.
I'm happy to be out because I just really wanted her to be held responsible for what she did.
Sarah and Judy.
So a trend I've seen a lot here is plaintiffs suing for wrongful eviction when they're a month-to-month tenant. And for what I've learned in landlord-tenant law in New York, I know it varies a lot from state to state, is the landlord only has to give you as much notice as your term, which if you're a month-to-month tenant would be 30 days. So people have to really understand the legalese of their contract and of their lease, because if you feel like you're being wrongfully evicted as a month-to-month tenant, that's a different standard than if you have a standard year-long written lease.
Well, that's sort of the reason. I didn't think that the one instance that was raised was sufficient.
Court come to order. All rise.
Judge Judy enters.
Have a seat, please.
Kevin approaches the bench.
Case 2110, Costello versus Knapp.
Thank you.
You're welcome.
Mr. Costello, you and Mr. Knapp were out drinking in the park.
Yes.
Date and time.
The date and time was around 3 a.m. and it was on 9/11 of 2021.
And you've known Mr. Knapp for how long?
Roughly 9 years. We started off playing high school baseball.
And when had you first met up on September 11th?
I can't remember the exact time. I would say around maybe 7 p.m.
Where?
at a bar over in Old Town Pasadena. We weren't meeting up.
Just a second.
Yeah.
So you were in a bar in Pasadena, 7 p.m., just the two of you, or were there more people?
No.
How many were there in the whole group?
I had around 5 or 6 people in my group, and we went
All
to a
friends?
Bar. Yeah.
And you?
He wasn't a part of that group.
But you were at the bar?
No, ma'am. I was at work when he contacted me.
Okay, so so you were at the bar starting at 7 with your friends. He wasn't there.
Yeah.
Okay, what time did he join you?
It wasn't, I couldn't tell you the exact time.
Approximately.
About an hour later.
At the bar?
Yeah. But it wasn't a text or anything like that. He just happened to go to the same bar.
No, ma'am. What ended up happening from the start, I was at work. He contacted me via text. I don't
Do you have that text?
No, ma'am. I tried to erase the whole memory from my mind, so I deleted all the pictures and all the text
Oh, well,
messages.
that's unfortunate.
Yes.
That's unfortunate. I've never done that, by the way. You know, wanted to erase something from my mind, so I didn't just say I'm not going to think about it anymore. I've never done that. Did you ever do that, Sarah?
I have not.
You have not? And she's pretty efficient with text messages. Did you ever do that?
Never have I done that.
No. Well, you must be unusual, sir. Okay, so you met at the bar. What time did you get there?
Well, my shift ended at around 9 o'clock.
What time did you get to the bar?
10 o'clock.
And when you got to the bar, you met Mr. Costello.
Yes, ma'am.
He had a few friends with him. How long did you stay at the bar?
We were there till 12.
Okay, so Mr. Costello, you had been drinking from 7 until about 12.
Correct.
The answer is yes. Yes, of course. And what's your drink of choice, sir?
Beer.
What else?
The first bar that we were at doesn't serve hard alcohol, so it was just beer there.
Okay, so from 7 to when were you at the first bar?
Yeah.
From 7 to when?
7 to when? Till
To
12.
12.
Yeah.
So it's
But I
7
was
to
driving
12.
at the same time as well.
Okay, so from 7 to 12, you were drinking beer.
Yeah.
And then where did you go at 12 o'clock?
After 12 o'clock, we ended up going to another bar in Arcadia.
Okay, and you stayed there from when to when?
From 12 to closing, which is 2 a.m.
And you were part of that group?
Yes, that's when I initially met the group.
At the second bar or
At
the
the
first?
second bar, yes.
Not at the first bar?
No, ma'am.
Okay, so you got to the second bar, you were there about, you said you were there at 10 o'clock.
Yes.
So they weren't there when you arrived.
They were there when I arrived, yes.
Well, he said that, I thought he said he got to the second bar at 12 o'clock.
I arrived at the bar at around 10 o'clock, ma'am.
And you got there at 12 o'clock.
Yeah.
Yeah. So by the time you all got together and left the bar, you had all been drinking, you for a very long time and you for a shorter time.
Yes, ma'am.
So from 10 to 2, so 4 hours. And what's your drink of choice?
10 to 12, Your Honor. I apologize. 10 to 12.
Where did you go at 12 o'clock?
12 o'clock is when we had all decided to go to a park, kind of a low-key area.
No, he said that he went to a bar between 7 and 12. Am I correct, Whitney? Did he say?
7 and 12.
He said you were at the bar, first bar, between 7 and 12, drinking beer. That's what you said.
Correct.
You said the first bar only served beer. Is not an answer. Yes,
Yes,
is an
it does.
answer. You say at 12 o'clock, you went to a second bar where you had alcohol between 12 and 2.
Yes.
Yes?
Correct.
You got to a bar at 10 o'clock.
Yes.
Which one? The beer bar or the alcohol bar?
I finished my shift, like I said, at 9, and I showed up at the bar at 10 to meet up with them, to try to rekindle an old friendship.
Okay, yeah. I actually don't care about that. All right, so partially you got your story straight, partially not. Anyway, you were two drunks. Now it's after 2 o'clock, and you decide to go to a park. How many people went to a park, and what park?
It was the same amount of people that I was with from the start.
And you were along at the park?
Yes, ma'am. Yes, it was.
Okay, did you take any beers to the park, or you went without them? You took
Yes.
beers to the park. The answer is yes.
Yeah, the main reasoning of going to the park was after the bar had closed. Jacob mentioned to the group that he had beers with him. So that incited us to go to the park and have some beers
continue
with him.
drinking.
Exactly.
Yeah.
Yes, prior to me showing up, I did stop by 7-Eleven and pick
Okay, so you had beers with you, and you were at the bar?
Yes.
Nice, very good. Now you get to the park, you're drinking beers. Now you're going to describe what you say is the assault that you suffered at the hands of Mr. Knapp. Now, I want you to know my feeling before you tell me the story.
Okay.
I usually don't get myself overly exercised about what drunks do in a park. Do you understand? Mm-hmm. I know that you may be all exercised about it, although I'm not exactly sure you're all exercised about it. So if you really are, I'm going to listen to you. If you're not,
Yeah.
we just eliminate this case. Do you understand?
Yes, ma'am.
Caption, coming up.
If he just simply tossed me a beer, I don't understand how a beer can could chip my tooth the way that it
Just
did.
a second. I can eat a biscotti and it can chip my tooth. Biscotti, that's a cookie. And have. I mean, I could chip my tooth on my grandmother's steak. It was so hard.
Jacob smirks. A courthouse. The Judy Justice logo appears. In the courtroom, Giovanni and Jacob.
Giovanni Costello claims his former friend, Jacob Knapp, owes for dental bills after being hit in the mouth with a beer can.
Okay, go. You're in the park, drunk.
Starting at
He's
the
in the
park, yes.
park, drunk.
Yes.
And
To state I was not drunk because I was driving my witness here.
I
my
want to
friend
tell you
Maureen.
something. If you were drinking
Right.
from 7 to 2, you were
I
drunk.
hadn't been drinking the whole time that I was
Let's
there.
go. Let's go.
Okay. So going into it, I was sitting at a park bench with Maureen here, and then I had another two friends that were on the other side, and we're hanging out. They had the two across from me got up. They went further into the park, and I was sitting with just her alone. And I was just about to show her a video off my phone. Next thing I know, I get hit in the face by a beer. After that occurs, I reach to my mouth to see something's wrong there, and I feel that like a part of my tooth is missing.
Okay, and that's what we're talking about.
Yeah.
That's the assault that you're talking about.
Yeah.
And you allege that Mr. Knapp was the one who threw the beer bottle.
Yes,
Okay,
it was a full beer can.
a can.
Yeah, not bottle.
I have
Did
to
you
disagree.
report
I'm
this
sorry.
incident to the police?
I did not take it to the police
Just a
because...
second, I'm just asking you.
Oh, sorry.
The answer is no.
No.
I disagree. With
Disagree that he went to the police?
With his story.
Okay, I'll get there. Okay, so now you get hit in the face with a beer can, step by step. You look down, you look at your tooth.
Realize it's chipped. I say out loud, my tooth is chipped. She doesn't.
Don't tell me
believe it at
not
first.
about she, just you.
Just me. I noticed it was chipped, and then after I announced that it was chipped, several of my friends, I guess, went towards him, and I
Well,
don't
you
know.
didn't tell me anything about him. You didn't tell me. You just said you got hit in the face with a beer can.
Yeah.
That's all you said to
And
me.
he was the only other person that was standing right there, besides her sitting
Just a
next to
second.
me.
So you didn't see him throw the beer can at you.
There was no one else there.
I'm just.
Yeah. Oh, sorry. I didn't see him throw it at me, but there was never a case of
No, you didn't.
Of anything
That's
else, yeah.
all.
Yeah.
You didn't see him throw it at you.
No.
Okay, go.
From the park, Your Honor?
Take it from
All
the
right.
park.
So
Now I got 2 drunks in the park, maybe 3.
there was actually more than just 3 of us surrounding the table.
Just a second.
Me and
Go
him-
slowly.
Okay, sorry.
Slower.
Let me take
I
it
don't
down a
know
notch.
table. I have no idea what you're talking about.
So, as he was saying, we were sitting at a park bench. I had brought the beer. The beer was next to me. He had asked me to toss him a beer. And that's plainly what
Okay.
I did was I underhanded him lightly a beer to him. And in his defense, he's saying he wasn't drunk, but it definitely was apparent that he was. When you lightly
Anybody who's been
toss a
drinking
beer,
from 7 to 2 in the morning is drunk.
yes, ma'am. So I lightly tossed him a beer, and unfortunately, it was dark enough to where he had missed, and the beer had hit him in the face. In which, after immediately, I started to apologize to him, stating that I didn't mean to, but it was apparent he was looking at me and did not catch the beer. So personally, I think everything he said to you
Okay,
right now was
that's your story. You tossed him a beer
Yeah.
because he asked you. He said, toss me a beer.
yes, Your Honor.
And it was dark,
Yes,
and you were drunk, and he was drunk.
I wasn't drunk, Your Honor. I had 4 beers within the time of 10 o'clock till
I'm not-
when this incident happened.
You know, I'm not real comfortable with that, sir.
Okay.
Because according to you, you had been drinking for 4 hours. And not only were you drinking for 4 hours, but you brought extra alcohol to have in the park. By the way,
Which was a
by the
closed
way,
container.
where do you live? In what
In
city?
Pasadena, Your Honor.
In California. Are you allowed to drink alcohol in parks in California?
I'm not certain.
Well, let's find out. Open beer cans in city parks in California.
That's a no.
So after,
We're not talking yet.
I'm sorry, excuse me.
Drinking alcoholic beverages is a prohibited activity in parks and park areas, according to the Pasadena City Park rules.
Thank you. This park that you went to, what's the name of it?
I'm not sure. It was up the street from the last bar we were at.
Okay. Now, did you, Mr. Costello, and the defendant, immediately after this event, did you communicate with him via text or email?
I texted him, I think it was roughly a couple of days later.
Okay. I'd like to see the text.
I have that.
That's all I
The
want to
other
see.
thing I could-
Don't say anything else. to
Okay.
me. Just show me the texts that you sent him a couple of days later.
There it is.
Giovanni hands a document to Kevin, who brings it to Judy.
Okay, thanks, Kevin. I'd like to see these texts from your phone, and I'd like to see all your text messages starting September 14th
It's right here.
of 2021.
Giovanni hands his phone to Kevin, who brings it to Judy. She reviews it.
No, sir, you have to understand. What you said to me here, what you gave me, is 2 texts a year apart. I want to see the texts to him
There was nothing.
after September 14th. You mean he didn't respond at all
The
to
next-
this? I don't believe that.
My next thing that I did was I sent a letter through the mail, and I have that here, and I have proof of it where I had it so where he had to sign for it, and I have the receipt for it as well.
What date?
That one, I can pull it up right here.
I'm sorry, what letter? I never received a letter.
Just a second. So what you're telling me is that I'm supposed to believe that after you sent this email on September 14th, which is 3 days after the event, he never responded to you and you never sent a follow-up email or text.
That was the letter. And in the letter I gave him,
Shh, just a second.
okay.
Kevin hands a document to Judy.
Oh, here, take this back. It's nonsense.
He returns it to Giovanni.
I don't want to see something prepared for litigation, sir. You said you had a document that you sent to him that he had to sign for. If you sent him a letter, return receipt requested, then you have a return receipt requested with a signature on it. That's a document that you prepared 2 days ago.
I have the receipt in here.
Let's get it.
Okay.
I never signed such document.
Don't shout out again.
Yes, ma'am.
It's annoying, and I'm annoyed enough with this case.
I'm sorry for being so unorganized.
Me too.
Yeah.
I'm sorry you're so unorganized too, or disorganized.
Oh, here it is.
Great.
Certified mail.
Giovanni hands a document to Kevin, who brings it to Judy.
They're stuck to the back one.
She reviews it.
This was sent April of 2022. I want to see what the response was. There had to be a response
I never got a
since
response from
September
him.
14th, 2021. There had to be a response.
I never got a response from him.
Kevin, show this to Mr. Knapp and tell me if he recalls this text message.
Kevin brings a document to Jacob, who reviews it.
Your Honor, no, I do not remember getting this text.
Why would you respond a year later? I know from the past, dealing with Mr. Knapp here, he tends to always, being friends, whenever get into an altercation or argument, he unfollows me, blocks me on everything.
Okay.
So there's a possibility by that text message not going through.
I don't deal in possibilities, sir.
I sent the text message, and I have proof of there. It was delivered, and I never got a response from him.
I'm just asking.
Yeah.
Sir, this incident happened September 11th. You have to understand, I think that if that's what happened. I tend to believe that the defendant did not just willy-nilly take a can and fling it at your face. I want you to know that I don't believe that.
Caption, coming up.
You were stupid enough to throw the beer can in his direction. You're two drunks, that's what happens. So don't get so drunk and go to a park. How old are you?
27.
27 is, and you?
28, Your Honor.
28. You know, old enough not to be so stupid.
Giovanni nods. The courthouse. The Judy Justice logo appears. In the courtroom, Giovanni and Jacob.
Giovanni Castillo has accused his former friend, Jacob Knapp, of hitting him with a beer can. Jacob says Giovanni asked him to throw it.
Okay, it is more likely than not, that you were sitting with this lady who, according to you, you were supposed to drive home. That's what you said 5 minutes ago. So you were supposed to drive home, which means she was trashed, because that's what you said. You said, I wasn't...
This was the arrangements from the very beginning of the night.
Okay. Do you understand? So we had a whole bunch of trashed people. And I am more likely to believe the defendant when he says you said to him, toss me a beer, and it accidentally hit you in the face.
My questioning is that the...
I don't answer questions.
Okay, well, where the beer was placed on the table, I don't understand why I would have to ask him to toss me a beer when I can simply reach over and grab one myself.
I don't know either. But
no
it
sense.
sounds more likely to me than not that it was his beer, he brought it there, and you said to him, toss me a beer, and you failed to catch it. Now, that doesn't mean that the defendant isn't at least partially responsible for the stupidity of that night. But you have some responsibility, too, because I really don't believe that he left the bar. He was angry and frustrated over something that you had no idea what he was angry and frustrated over, because you were all sitting together, and he just, out of the blue, took a beer and threw it at your face. I don't believe that. Do you understand?
If I could show you a picture here, you could see that if he just simply tossed me a beer, I don't understand how a beer can could chip my tooth the way that it did.
Just a second. It can. It can.
Okay.
I can eat a biscotti and it can chip my tooth. Biscotti, that's a cookie, a very hard cookie. And have. And have. I mean, I could chip my tooth on my grandmother's steak, it was so hard. But certainly from a beer can. So I don't believe that you're blameless. What was your dental bill, sir?
I have the statements here.
While he's looking for that, you understand that if you were sitting there and instead of a bunch of beer cans and the plaintiff said to you, you know, that gun that's in your pocket, toss it over to me, I want to take a look at it. And you did. You took a gun out of your pocket and you tossed it over to him, and as you were tossing it over, it accidentally fired. Would it be his fault if he got shot?
No.
No. Whose fault would it be?
Mine.
Right. Because you weren't supposed to do that, because it was potentially dangerous.
Of course.
Well, same thing with a knife or an explosive device.
Right.
Or something very hot, like toss me a cup of coffee in a container and it splatters. So you don't do what anybody asks you to do if it's not a smart thing to do.
Right.
Unless you're drunk. Unless you're drunk.
Your Honor,
then,
if I may.
Yeah.
Coming from a baseball background, such as me and Gio did,
I don't care about your baseball background. There's no question, sir, that you acknowledge you threw it at him. And I'm telling you that if your excuse is that he asked me to do it, so I followed the fool's directions. I'm telling you, he's going to pay part of his dental bill because I think it was partially his responsibility. But if you acknowledge that you were stupid enough to throw the beer can in his direction, you have to be partially liable. You're two drunks, that's what happens. So don't get so drunk and go to a park. How old are you?
27.
27 is, and you?
28, Your Honor.
28. You know, old enough not to be so stupid. You know, you can figure 17, 18-year-olds are so stupid. At age 28, you should be doing something constructive. I assume you work?
Yes.
What kind of work do you do?
I'm a chef.
And you?
I'm a lumberman, Your Honor.
Okay, so you're both gainfully employed, letting off a little steam. That's fine. But if there's a problem that develops because anybody is not operating on all cylinders because of alcohol, you have to take responsibility. What was the dental bill?
My dental bill came out to $2,342.
Can I see that, please, Kevin?
I have this here. I'll give you both.
Giovanni hands a document to Kevin, who brings it to Judy. She reviews it.
Was any of this dental bill covered by insurance?
On the dental, no.
Okay. Anything else?
My wholeheartedly truth is I didn't ask him for a beer. I had no problems. I was avoiding him the whole night for the most part because from the past, Jacob has had a way worse drinking problem than I've ever, gotten to. I went out that night solely to have a couple drinks, hang out with friends. The night went longer than expected.
Very nice. Judgment for the plaintiff in the amount of $1,171, which is half of your dental bill. You pay half. Don't get drunk. You're too old to get drunk. I don't believe that he maliciously threw this at you. I think that you asked for a beer, tossed it at you, and you missed. That was his stupidity and yours. We're done here. Thank you very much.
Thank you, Your Honor.
This court is adjourned.
All I did was I underhand lightly tossed it over to him, and that's really what happened.
I did nothing wrong to deserve to get a beer thrown in my face like a baseball.
Unfortunately, he chipped his tooth, and so it was unfortunate.
I said, hey, Jacob, look, you chipped my tooth. Look what you just did.
No more drinking in the parks, guys.
Not to do it again.
Sarah.
I think this situation is the exact reason.
Court come to order. All rise.
Have a seat, please.
Kevin.
Hello, Judge. Case 2086, Renner versus Velasquez.
Thank you.
You're welcome.
Miss Renner, you run a dance studio.
I do.
How long have you had it?
30 years.
And what age children do you teach?
We have a Mommy and Me class, which starts at 18 months, and our oldest student is 19 years old.
And Miss Velasquez has a daughter. And she was at your school during what period of time?
She started in June of 2020, and she quit in June of this year.
Your lawsuit is simple. You claim that Miss Velasquez owes you money for her daughter's dance lessons.
Yes.
The defendant actually disavows owing you any money. She said that you actually behaved in a mean-spirited way in not allowing her daughter to finish her recital. So I'm trying to think back to my days when I was 6 and 7. And if I remember correctly, the name of the school that I went to, and I know that this is not something that everybody is breathless to hear about, but I haven't had one of these cases. And I was thinking back to Miss Nottage, who had a dancing school in her home on Parkside Avenue in Brooklyn. And I do remember that you took classes I took toe, tap, ballet, and acrobatics, which was not my strong suit. Any of them, none of them were my strong suit. Father always said that I should sue the city because they built the sidewalk too close to my behind because my legs are short. So being a ballerina was really not physically possible for me, but in my mind, I thought I was a ballerina. Anyway, as do most little girls, I assume. So you worked during the year, and at the end of the year of your dance class, I remember you gave a recital. Everybody got all excited and dressed for the recital. I assume that's what happens in your class. Yes, that's a yes.
Yes.
Did you have a contract with Miss Velasquez?
I have a registration form which acknowledges receipt of studio policies.
Well, policies is not a contract, but I'll take a look at it anyway. The question is, do you have a signed contract with her?
No.
Okay. May I take a look at that?
Jennifer hands a document to Kevin, who brings it to Judy. She reviews it.
According to these policies, which are not a written contract because she has not signed this document in particular, you say you acknowledge receipt of it. What it mostly is tell them what the instructions are and give you a release of liability. It does indicate here that full tuition is due on the first class of each month. And how much was the tuition for Miss Velasquez's daughter?
From January through June, it was $170 a month. And then from September through December, it was $165 a month.
Okay, so around $170 a month. And I assume she was current on her tuition in 2020. And in 2020, did Miss Velasquez make her payments on the first of each month?
Well, I can't say exactly on the first, but yes, it was always current, which is
That's
why.
not what I asked you. Was it made pursuant to your policies here on the first of each month?
I don't know. I don't remember specifically.
What about in 2021? Were her payments made on the first of each month?
No.
When did she stop making payments in 2021 on the first of each month?
Well, I have emailed spreadsheets here, and so starting in December, she asked me if she could make small payments, increments throughout the month because she was a single mother and wasn't able to make the full payment on the first.
So you said yes, that she could make payments incrementally. And do you have that same arrangement with some other parents?
I do.
How many other parents do you have that arrangement with?
Well, anybody who asks in
How many? You run the school.
5.
How many students do you have?
5.
Okay. So you have that arrangement with this mother plus 5? And that is inconsistent with your policies.
Yes.
That would be a yes. Now, tell me what happened, Miss Velasquez, that caused you to fall behind in your payments. You acknowledge you fell behind in your payments.
Yes, I do.
When did you fall behind in your payments?
I asked Ms. Renner if I could start making payments in September of 2021, which I have written as well, if you would like to see that. And in October, I didn't pay anything because my father passed away. And I explained that to her, and then I made up for it in November through payments, and I just continued to pay as I could with being a single mom.
Well, that's not a reason to not pay her, being a single mom, as you could. You understand that?
Yeah, absolutely.
Okay, so I'm sure you're doing the best you can. You're trying to give your little girl, how old is she?
9.
9. Trying to give her the best possible experience. It's all wonderful, but this is her business. And if you owe her money, then you owe her money. Since the policies are honored and sometimes not, there is one part of your policy, even though that this is a contract that I actually find ridiculous, because in your lawsuit, you claim you're owed $946 and $7,169.76 interest. That's not happening. And it's not happening. You gave me an easy out because you really don't enforce your own policies.
I try to be kind to people who
And I
need
try
help.
to be kind too. Being kind is not suing somebody for $900 and suing them for $9,000. That's not being kind, because, you know, there's no question that you agree that you
Yeah.
owe her some money.
Yeah.
Okay? But it's an unconscionable, even if there was a contract for it, I would probably find it an unconscionable piece for somebody who owes you less than $1,000 and you want $7,200 because it includes interest. I find that ridiculous. How many students were in Miss Velasquez's class?
Approximately 18.
When you say approximately 18, the number varied based on what?
Well, my memory, it was either 18 or 19 children. I don't remember how many. That's a very large class.
Are you the sole teacher?
Well, I do the ballet, and I have a teacher who teaches the jazz class.
Your daughter takes ballet or jazz or both?
Yeah.
Your daughter stopped going to school when?
May 17th.
Tell me the circumstances.
That was when I got a ledger from the studio that said that I owed $965. And my math was thinking I was closer to like 360. So I kept messaging and asking where the confusion was. And I didn't get a response until May 27th.
That said what?
That said I owed $1,300. And this was from Miss Jenny.
And that was for late fees? What was it for?
The dance team and the costumes for the recital that was coming up.
Okay. Well, do you have a ledger? And I'd like to see your ledger. So far, I have, according to you, what you owe, because you did a breakdown of what you owe. It is your claim that you owe $846, correct?
Yep.
And she says you owe $946. That's without the interest and the late fees.
Yeah.
So you are actually, based upon raw numbers, $100 apart.
I have an email from her stating that she owes $947.
I'd like to see it, please.
And later today,
Do you keep a certain amount of clothes at Miss Barnes' apartment?
No, Your Honor, they're usually in my truck.
So you stay with your mom?
Yeah, that's my primary residence. Like, it's maybe two days out of a week.
Mr. White, this is what we're getting. You see where we're starting to smile now?
A courthouse. The Judy Justice logo appears. In the courtroom, Jennifer and Danny.
Jennifer Renner claims her client, Danny Velasquez, owes for dance class fees.
Okay, so in this email, you acknowledge owing $586 and then $360 for team. What is team?
They did like competition teams that I allowed my daughter to be on. Before I let her audition, I made sure that Jenny was okay with my payments and I sent it all in.
No, I'm just reading the email, which seems to acknowledge that you owed her $947.
Yeah, so the team portion was $361, which is what I thought was owed.
No, you said team, and your regular tuition said that I owed $1,301 when I only owed $586. So $586 and $361 and $947.
You're correct. I just couldn't get any accurate numbers.
I'm taking your numbers that you acknowledge.
Right. First she said it was $1,647 I owed, then she said $1,400.
Right now I have, she says amount owed $946. You said it was $947. So let's say it's $947. And that's without late fees and without interest. So you would consider that a fair number.
Yeah.
And Ms. Rayner, you would consider that a fair number?
Yes.
Judgment for the plaintiff. We're finished. Thank you very much.
Thank you.
This court is adjourned.
Outside the courtroom, Danny, then Jennifer.
I think it was fair. I just wish that my daughter would have been able to dance.
Money was due to me, and she was not paying.
I had to go in and be the one that broke her heart.
She argued with every statement we sent her.
We've already found a new studio, and it's amazing.
Pay your bills.
It's a big blessing in disguise that my daughter's not with Jenny anymore.
Sarah and Judy.
I'm sure you were a great dancer back in your day. Maybe ballet now isn't for you, but I'm sure you were the cutest one in the class. But I do think it was unconscionable for the owner of the dance studio to agree that the mother only owed around $900, and she wanted to have this court pay her almost $9,000 in late fees and interest. I mean, I think just unconscionable.
It was a good shot. You know, usually when you do a contract, a formal contract, contracts usually say if any part of this contract is found to be either unconscionable or illegal, the remainder of the contract remains in full force and effect. Usually you have something that says that. Well, this was just an acceptance of the school policy, but the school policy clearly was flexible.
It was, and as soon as she said that, I was hoping that she would have drawn up for those 5 or 6 parents that were on a different payment plan. I would have hoped that she, as a business owner, would have drawn up something mimicking a contract with them to show what their agreement was.
Memorialize that agreement.
Because as you said, well, if you're flexible on this point and that point, why are you not flexible on the interest that you...
The interest point,
exactly.
which sounded unconscionable.
It did.
Anyway, I really, Sarah, remember those dance classes and crossing Parkside Avenue to go to Miss Nottage's studio. The thing that I remember most about it was the acrobatics class. I swear they had something strung up that looked like a torture chamber. It was strung up from the ceilings and you were put in a harness. You started from one end of the room, and when you got to the minute, she pulled you up on a pulley and you were supposed to do a somersault. And I remember I couldn't get off the ground. My little chubby legs were
flailing,
and I couldn't get my behind over the rest of my body.
Listen, I'm not a dancer either.
And then I started thinking about law school.
Yeah, I think that's a good career path.
Right.
Case 2088, Jenkins versus Barnes. All parties, please step forward.
Fenshia Jenkins is suing her former roommate, Victoria Barnes, for rent and a security deposit.
Miss Jenkins, you were a short-term roommate of the defendants.
Yes, ma'am.
She put an ad on the internet.
Yes, it was in a Facebook group. I was referred by my college. It was for subleasing, rentals, apartments, of that sort.
A room?
Yes.
Do you have a copy of the ad?
I actually do.
I would love to take a look at it.
No problem.
Fenshia produces a document.
What college do you go to?
University of Alabama at Birmingham.
Kevin brings the document to Judy, who reviews it.
Miss Barnes, you were pretty specific in this. It says it's average about $800 a month. Utilities included, unfurnished, looking for a female roommate, sublease, personal, bedroom and bathroom, pool, tennis, laundry site. Must be willing to complete a background check.
Yes.
Okay. And did you go to look at the room?
Yes, ma'am.
On what date?
It was the same day that I signed the sublease, which was, I'm so sorry.
It was February the 10th.
No, I moved in on February the 10th. That is incorrect. We signed our sublease on I believe it was actually maybe January 22nd.
Does it have a date on it?
This only has the date for when I will be moving in and
May
moving
I
out.
please see it?
The date is on the signature page.
Okay. It's on the last page of that packet.
You don't have to help her prove her case.
I just want to make sure she got it right.
You don't have to help her prove her
Yes,
case.
ma'am.
Judy reviews a document.
Well, who crossed this out? It says subleasee is one of, first it said one, that's crossed out, and then it said two total tenants occupying the premises.
I did cross that out because it is two of us. And I accidentally wrote one of one, but it's two of us total. And that was crossed out on the date that I signed it.
Is that correct?
Yes, it was quite a few changes on there.
So it was agreed that there would only be the two of you occupying the premises.
Not completely correct.
That's what it says, that there would be two people
Yes, ma'am.
occupying the premises. Am I correct?
In the initial agreement, I made it clear that...
No clear. This says the sublessee's interest in the sublessee is one of two total tenants occupying the premises. That's what the lease says, which means there are only two people, according to this sublease, which is signed, who will be occupying the premises. That's all it says. I haven't finished the next page yet, but that's what the lease says. Not what you made clear, not what you might have said outside of this. This is what's binding.
Okay.
And this indicates that the subleasee, that's you,
Yes, ma'am.
does not need to obtain her permission
Not at all.
overnight guests, which would make sense that she doesn't need your permission to have overnight guests.
Yes, ma'am.
Okay. This is what your case is about. Now I've read this agreement. You moved in February 10th?
Yes, ma'am.
And started to have difficulty because Miss Barnes has a boyfriend. That would be you.
Yes, ma'am.
And he was there a lot.
No, that was not a problem.
Well, according to you, it was a problem when he had his own key.
Yes.
And he came, according to you, unannounced.
Yes, ma'am. Alone.
Well, it doesn't say that he has to be announced. I can understand it if he was occupying the residence with his own key and there all the time. That certainly would be in violation of the lease. Would you stand up for a second? Tell me your name, sir.
It's Sean White.
Are you and the defendant currently living together now?
No.
Have you ever lived together?
No.
Can you tell me why it would be that you would have a key to her premises?
Well, she is my fiance. We've been together almost...
Because she's your fiance?
Yeah.
When did she become your fiance?
Around a year ago.
And is there any reason why you're not living together?
Yes. In recent...
Yes. You're going to tell me.
Yes, ma'am. I'll tell you. In recent events, I just lost my father, and I'm trying to launch my trucking company and get that off the ground, so it's just... wouldn't be the best thing right now.
But far is your residence from your fiance's?
About an hour and a half.
And her residence from your business?
I'm a truck driver, so I'm always mobile, but where I load at, she's usually close to it.
And that's when you stay at the house?
Yeah.
And how many times a week do you load your truck?
Close to her, maybe 2 or 3 times.
2 or 3 times a week?
Yeah.
So that means that you're spending either 2 or 3 nights a week at her house?
Yes.
Yes. And that's been going on for how long, sir?
Just this year.
So far, we're doing fine. You see, I don't yell unless someone provokes me.
Caption coming up.
He seems like a very nice man, nothing that frightens me, right?
Thank you.
And he visits his mother on Sunday. The guy is a hero, perfect for you.
Thank you.
I don't know what you want from her.
Fanshaya and Victoria turn to one another. A courthouse. The Judy Justice logo appears. In the courtroom, Fanshaya and Victoria.
Fanshaya Jenkins claims her former roommate, Victoria Barnes, owes for rent and a security deposit.
Mr. White, do you keep a certain amount of clothes at Miss Barnes' apartment?
No, Your Honor, they're usually in my truck.
When you're going to stay over, do you bring up a bag or do you bring up a backpack? What do you bring up with you?
A bag and a backpack.
Do you have toiletries in her bathroom?
No, ma'am.
You carry that with you?
Yes.
Now, when you're on the road, if you stay over 2 or 3 days a week at Miss Barnes's house and you're on the road, how many days a week are you on the road and sleeping either in your truck or at a motel or at a truck stop?
Between 2 and 3 days. It's all depending on where I go.
So that brings us to maybe 5 days a week or 6 days a week. And where is your home?
Aforementioned 1 hour.
Is that where your father lives?
I'm sorry, but he's passed.
Oh, he passed?
Yes.
Okay, so the house that you're staying in is his house?
Yeah.
Anybody else live there?
My mother.
So that 1 day a week you stay with your mom?
It's usually probably a Sunday when I don't have anything to do.
Do you stay at your mother's house?
Yes, that's my primary residence. Like it's maybe two days out of a week.
Mr. White, this is what we're getting. You see where we're starting to smile now? If you see your mother on Sundays and you're on the road half the week and you're at the defendant's house half a week, you can tell me from today until the cows come home that your mother's house is your primary residence. But if you look at it objectively, put your hand down. If you look at it objectively, you're on the road part-time. When you're not on the road, 3 times as many days a week you stay at her house. 1 day you stay at your mother's house, and you tell me that that's been going on since the beginning of the year, which would be January or so of 2022. That's what you just told me, and that actually makes sense.
I beg to differ though. Like the time that I stay there, it might be 8 hours, and then I'm back on the road.
I don't care.
And it's like maybe 2 days out of the week.
Now you can sit down, Mr. White.
Wait.
Okay, I get the scenario, and not unusual, you were unhappy with this more frequent access than you were advised of.
May I add, I was not unhappy with how much he was there. It was only the fact that he had came in by himself and she hadn't let me know. I only had told her that that made me uncomfortable, and I got kicked out for it.
That's not true, Your Honor.
Well, when you say got kicked out, I think you acknowledge that you gave her a 30-day notice to leave.
Yes, ma'am, I did.
And other than this issue of house guests, were there any other issues that you had with her?
When the situation happened, she texted me and asked me where I was. I told her when I got home that we can have a conversation, and that's when an argument ensued, and multiple arguments happened after that.
Were they all about house guests?
Just about, yes, ma'am.
And at the beginning, they were all about Mr. White.
Right.
Okay. And your sublease agreement actually specifically says that only 2 people are living there.
Yes, ma'am.
And Mr. White has already made it crystal clear to me that he spends his time either on the road or at your house visiting his mom on Sunday. And that sort of makes this fuzzy. Okay, anyway, it didn't work out. He seems like a very nice man, nothing that frightens me.
Thank you.
Right?
Thank you.
And he visits his mother on Sunday. The guy is a hero. Perfect for you.
Thank you.
So you moved out, you got another apartment, whatever it is. I don't know what you want from her.
I want the money that I gave her, period. And
What money?
So she made me pay her security deposit.
No, just a second.
Yes, ma'am.
Security deposit.
Yes.
Fine. Did you get your security
No, ma'am.
deposit back?
Absolutely not.
How much was your security deposit?
$350.
Okay. Did you return her security deposit?
No, ma'am.
Okay. You have to return her security deposit.
Well, being as though she left the room damaged, I didn't feel like I needed to.
You have photographs of the damage?
I have stained carpets.
Just a second. Do you have photographs of the damage?
No, ma'am.
Good. $350. She gets her security deposit back.
Yes, ma'am.
What's next?
The remainder of the rent for the month that I moved out, which I moved out within.
Just a second.
Yes.
Did you pay her March's rent?
Yes, ma'am.
You did?
Yes, ma'am.
Okay. You paid that the beginning of the month?
Yes, ma'am.
Okay. And how much did you pay her?
$630.
Incorrect.
Clearly paid you February's rent when she moved in.
Yes, ma'am.
Did she pay you March's rent?
So she gave me...
That's either a yes or a no. If she paid you March's rent, did you get 2 months' rent from the plaintiff?
Yes, I did.
Okay. And she moved out.
Can I explain why I don't feel like I'm entitled to give her the money back? Because the apartment complex, when we got into the initial argument and I was made aware of the slander and the allegations that she was portraying against Sean and myself, I was told that being as though I made it legal on paper that she has 30 days to the resident, that she would still access to my apartment for the remainder of the month of March until the 17th of April. And also Sean has seen her sending people to my house, her coming in and out of my house when I was at work, supposedly gathering her things, but my personal belongings came up missing.
Oh,
and she had access
Hold
to
on
it.
1 second. After March 17th, did you have any property in the apartment? Just be very careful what you say to me. After March 17th, you say you physically left the apartment. Did you have any property there? That's either a yes or a no.
May I confirm the date so I just don't give you false information? Okay, thank
Yes.
you. So the very last day that I was there was...
March 22nd.
Shh. You keep doing that. You keep doing that.
I'm sorry.
Okay, good.
Okay, so the very last day that I was there was on, I believe, March 20th.
Oh, then you owe for the month of March. then you get your security deposit back, $350. We're finished. Thank you very much.
That's all, Judge.
What? That's what she gets, her security deposit back. That's it. She gets her security back. Doesn't get rent, doesn't get moving costs, doesn't get damages. She gets her security deposit back. Goodbye. Have a happy life. Have a nice day.
This court is adjourned.
Ben Shia.
I really just thought that everything was fairly normal until just the conversation about me
A security deposit is the least of my concerns because I don't owe her rent.
expressing my discomfort with her boyfriend being in the house alone with me.
For her to even mention him harming her in any type of way is not only offensive, but it's disrespectful.
It wasn't like, he was my personal friend or I met him anywhere else. I met him through her, so I just didn't want to be home alone with him.
Honestly, it's outrageous. The implicate that I do anything to her is it's beyond me.
My safety does come first. I put me first. I gotta put me first.
I wish her nothing but the best away from me.
Judy and Sarah.
I thought that the fiancé was absolutely charming.
I did too.
I thought he was such a nice guy.
Visits his mom on Sundays, has a job.
Hard-working, regular, stayed home while his dad was ill.
Defamation of character.
Court come to order. All rise.
Have a seat, please.
Kevin.
Hello, Judge. Case 2103, Horn versus Stewart.
Thank you.
You're welcome.
Ms. Horn, it is your allegation that the defendant, for whom you worked for a relatively short period of time, owes you some wages.
Yes, ma'am.
And in addition to owing you wages, you are suing her because you claim she defamed you by calling you a drug addict.
And she went to my board telling them that I did other acts.
Well, you can't tell me what she told anybody else because that's hearsay.
Could I give you the evidence?
No, you have to wait until I'm finished.
Okay.
That's your claim, that she owes you money for wages that you weren't compensated for and that she defamed you. The defendant says that you were an hourly employee. You were, in fact, paid for the hours that you worked. I assume that you are claiming that she paid for the hours that she worked. She has a counterclaim, and her counterclaim is that after you separated, parted company, you posted some very damaging and defamatory comments on the internet about her organization. So why don't we start with you, Ms. Stewart, and tell me what kind of an organization you have.
Your Honor, what we do is that we provide opportunities for people who have substance abuse, behavior health, who may need education services such as getting their GED. We do skills training. We have employers that will staff them as well. And we also provide substance abuse and behavior health services.
Is it a 501c3 organization?
No, we are a for-profit company as a corporation.
And how many employees do you have?
We currently have 7 employees.
And when did Ms. Horn come to work for you, and what was she hired to do?
She was hired as the clinical director, and she started on July 21st, 2022.
Okay, before I go to Ms. Horn, I want you to tell me what special training did you have, or is it required to have? You're the director of this?
I'm the VP of operations.
Okay. Is there any special training that you had?
Besides having the master's in accounting, I have my own accounting firm.
Okay, so you have a master's in accounting, and you have your own firm?
Yes.
Okay, and you do operations for this? Okay, and Ms. Horn, I'd like you to tell me what your educational background. You were hired as the clinical director.
Yes, ma'am.
So tell me about your educational background.
I've been in the field for 15 years. I have a master's in counseling psychology. I have my LPC, which is an independent licensure. And so when she wanted to do illegal practices...
No. You're getting ahead of yourself, Ms. Horn.
Yes, ma'am.
Did you answer an ad?
Yes, ma'am. I went for the interview, and when I showed up for the interview, she told me that I could not oversee the clinicians, BHTs, and case managers, and that I could not sign off on notes because I had an LPC. I got the board on the phone that day, and
You're getting far ahead of yourself, Ms. Horn, and I'm just telling you, who is this person?
My dad, Your Honor.
Okay, I'm just telling you that what you're doing is, by not just answering my questions, you're not serving your cause well.
Yes, ma'am.
Do you understand?
Yes, ma'am.
Okay. Don't tell me what she told you she couldn't do. You started working for her on what date?
The date that I actually started working for her was July 27th, 2022.
And were you an hourly employee?
No, I was a salary employee. Could I show you?
Yes.
Thank you, Your Honor.
Sharna hands a document to Kevin.
Sarah, would you bring up a July calendar for me? I want to see the days in July.
I have it.
Okay, so this was an offer, and it was a pretty nice job. paid on a bi-weekly basis, $115,000 a year, with an increase the following year. The work offer was contingent upon a background check.
Yes, ma'am.
A drug test.
Yes, ma'am.
Participation in training, and any other safety measurements for staffing. So between July 21st and July 27th, when you started, was a background check completed?
It was completed.
That's all I wanted to know, was completed. Was a drug test completed?
Yes,
Not before she started, no.
Just a second. Between July 21st and July 27th was a drug test conducted?
Yes, ma'am.
It was conducted, but on the 28th, her drug test was done on the 28th of July, after she had started.
Okay, so you took it on the 28th.
Yes, ma'am.
I need from the 27th to August 3rd.
Yeah, the 27th was a Wednesday.
Yes.
August 3rd was the following Wednesday.
Okay, so she worked Wednesday, Thursday, and Friday.
And then the following
Monday and Tuesday.
The third
No,
would
ma'am.
be that Wednesday.
5 days.
No, ma'am. Monday, Tuesday, Wednesday, and Thursday of the last week. Her grand opening was the Thursday of that week that I quit. And what she is talking about, I talked about at the beginning before I took the drug test, and they said that it was no problem. I take medication that's prescribed by doctors, and I have proof that I take medication by doctors, and I'm not a drug addict.
Well, I don't want to get into what medication that you take that's prescribed by doctors. I would assume that we're not talking about blood pressure medication, and we're not talking about medication for migraines, and we're not talking about stuff to take care of rashes on your arm.
No, ma'am.
Okay. So let's say you worked there for 6 days. How much were you paid?
I was paid $55.29 an hour, but I worked those 7 days.
How much were you paid in total?
So the last paycheck that they gave me, $909.58.
May I see it?
Yes, ma'am. And I want to send up, I think I have the credit card because she had owed me money. And here are the days that I worked.
What is
circled?
Do you have a paycheck?
She did not give me a paycheck. The first one was a paycheck. The others were direct.
I want to know how much she paid you in total. Let's have it.
So for just wages itself,
that's all I want to know.
I was paid.
You want to tell me, do you have records, Ms. Stewart, about how much the plaintiff was paid by your organization?
She received 2 checks. She was paid $1,903.38.
$1,903. And that was for?
When we did the drug test, she was gone for over 5 hours. Drug testing are supposed to be done before or after work hours. Then she returned back to the facility between 4:30 and 5 p.m. that day and said that she had an emergency, that her friend was in the hospital, and so she could not work anytime. Then after that, on the next pay period, Sherna wasn't.
She really only was with you for 1 week.
Yes.
Caption coming up.
On what date did you tell her that?
About the 28th, yeah.
On the 28th, did you tell her that on the 21st?
No.
I'm just asking you.
No, because what happened that day was it was a confused interview where I was about to walk out.
Okay. Well, I'm getting unconfused.
Kimberly raises her eyebrows, then smirks. A courthouse. The Judy Justice logo appears. In the courtroom, Sharna and Kimberly.
Sharna Horn is suing her former employer, Kimberly Stewart, for unpaid wages and defamation of character. Kimberly is countersuing for property damage and slander.
So she really only was with you for 1 week.
Correct. And then on the next pay period, because she was paid for those 3 days and the time that she took off, we put her on the hourly rate because she didn't work a solid 2 weeks. But at any rate, we paid her for the time and days she was there. And so we don't owe her any money. She was paid.
Well, you were actually paid almost $2,000 and you were there for 5 days.
What she said was a lie. I never took off time.
Just a sec, I said something. Don't say what she said was a lie. You were paid almost $2,000 and you worked for 5 days.
7 days.
Well, when you went to take your drug test, what time did you leave?
Well, the other person...
Just what time did you leave?
I did not leave from anything. I did it on my own before I started.
So is what you're telling me that the defendant was incorrect when she said that you were gone from the facility?
Yes, ma'am.
Okay. Do you have anything to support that she was gone for 4 hours?
Ma'am, she was gone for half the day, because that's when she ran into my office and said, hey, there's some stuff that's going to show up. Will I be fired? Or am I going to have a job? So
when did you have that discussion with her?
That was on the 28th of July.
Did you ask her what substances?
Yes.
Did she tell you?
Yes.
Okay. From my information, Ms. Horn, yes, how much do you think, in addition to the $19.03 that you were paid, do you think you're owed?
10 hours, ma'am.
10 hours. Which 10 hours?
That's from the week of the second week, not the first week, because I never left. I actually stayed late the day before their grand opening because she ordered a sofa.
Are you charging her for those hours that you stayed late?
Yes, because that's work.
No. Okay. What else? Right now we're just playing with time.
I passed everything and I was told I would be fine.
Just a second. Who told you that? She?
Yes, ma'am.
When did she tell you you would be fine?
I went to her, I said, there's going to be a drug test. Here's the medications that I take.
On what date did you tell her that?
About the 28th, yeah.
On the 28th, did you tell her that on the 21st?
No.
I'm just asking you.
No, because what happened that day was it was a confused interview where I was about to walk out.
Okay. Well, I'm getting unconfused. So you went into her before she got the results of the test and asked her specifically, these are the medications that I take. This is what's going to show up. Is it going to be a problem?
This is common, Your Honor.
Is who?
This is common in my field, to take drug tests before all the field.
You're going to answer my question.
Yes, ma'am.
My question is, if you knew that it might have been a problem, you did not tell that to her on the 21st of July or the 22nd or the 23rd or when you started, but not until either right before or right after you took the drug test. That's when you said you went into her office and said, these are the medications that I take. Is it going to be a problem?
Yes, ma'am.
Mr. Horn, actually, I'm glad you're here with your daughter.
May I talk to her for a minute?
No.
Okay.
You may not talk to her.
Could I show you a picture of the inside of the facility of what happened in that facility, please?
No. You left. And
Yes,
I
ma'am.
find that the records are so, actually, you don't have records, unless that's something that you want to show me. You wanted to show
do.
me something about your employment hours? You were paid almost $2,000 for the few days you worked there. As far as I'm concerned, it didn't work out. You hated it there, and she wasn't crazy about you.
Because I had to leave because I was going to be violating state law and federal law, which she's already done, Your Honor.
I'm going to ask you, and you've been doing what you're doing for 15 years.
Yes, ma'am.
Tell me what job you had that lasted more than 3 years.
I've moved
Tell me who you worked for in the last 15 years, more than 3 years.
I can't because I was in graduate school and then I went to
So you weren't,
PhD.
just a second, so you weren't in this field for 15 years, you were in school?
I've been seeing clients since 2007.
Privately?
No.
Well, what I asked you is, who did you work for in the last 15 years, more than 3 years?
University.
Is that where you went to school?
Yes, ma'am.
Is that where you went to school for how many years?
5 years.
Your father wants to have a word with you before I'm finishing up with this case. You want to have a conversation with her?
You're blowing it. You answer her question directly and don't go anywhere else.
Okay.
Sharna returns to the plaintiff's table.
Was that helpful?
Yes, ma'am.
Okay. We're leaving the salary that you think you're owed. You
Yes,
say
ma'am.
that the defendant called you a drug addict and thereby limited your ability in your chosen field. So show me, tell me.
I would like to submit the board allegations because everything.
Just a second.
Judy reviews the document.
And may I provide the timeline for what happened?
What I want to know is, what is this?
That is a falsified document.
No, just say
submitted
it
to
is
my
a
board.
document.
To my board stating that I did things that I did not do. I highlighted the bottom.
To your board or to the board?
Shh. Okay, so this says a complaint was filed against you with the Arizona Board of Behavioral Health. Complaint alleges that you may have committed an act of unprofessional practice. If this is somebody filed a complaint against you.
She lodged a false complaint.
Shh. No, somebody lodged a complaint against you.
Yes, ma'am.
Doesn't say who lodged a complaint against you. It says a complaint has been filed. You didn't file this document.
Yes, she did.
Excuse me?
It's her signature at the bottom.
The types of documentation that were filed was list of medications, harassing and threatening emails and text messages, and budget left in desk. I don't know what that means.
She said I had all of my possessions, but how did she only have my budget?
Just, I'm telling you that this is what it says.
Yes, ma'am.
Okay? The CEO filed this document and you swore to the accuracy of this document. Well, this report says that you were complaining that the person who was doing intake had to have a master's level. Don't look at any papers. That's what you were complaining.
Yes,
That's
ma'am.
your first complaint.
Yes,
that
ma'am.
the person doing intake, and somebody said to you that the person who was doing intake was just taking basic information, and once the basic information was taken, they would be assigned to somebody else. But that's
Your
what
Honor,
it said.
She said that she wanted to get some substance use information. My state board gave me this paper that I'd like to submit.
Just a second. I don't care about your state board, actually. The question is, does she owe you any money? She doesn't owe you any money for salary. I've already determined that. I see what she was supposed to pay you. It's not that you were working there for days. You have hours that you think you want to be paid for. That's not happening. You were paid almost $2,000, and what I gather was a very acrimonious few days. I mean, you're talking about either 5 days or 7 days. You were compensated. Forget it.
Caption coming up.
Do you have any security footage of her?
I do.
Put your hand down.
She said she had
Put your hand down.
You're going to see the video.
No.
Not the video. She stated in a document she had video of it.
I don't think you understand the court process.
A courthouse. The Judy Justice logo appears. In the courtroom, Sharna and Kimberly.
Sharna Horn has accused her former employer, Kimberly Stewart, of defaming her. Kimberly claims Sharna caused property damage and slandered her business.
Okay, the only other thing that I have to determine is whether or not she called you a drug addict. Now, would you show me where she called you a drug addict?
It wasn't just the drug addict. It was the false documents that I
No. She's allowed to file a complaint against you,
But I
madam.
never had a police officer come to me, question me, or anything. So if I did it, they would have come to me.
Just a second. What I'm telling you is she is allowed to file a complaint against you.
Yes, ma'am.
They have a responsibility to look into the allegations of that complaint. Did they either sustain the allegations in this complaint? Well, this is just August, so I assume they haven't completed the investigation, or have they?
No, ma'am.
Okay, so they have not.
That's why I'm filing defamation, because this is doing it on purpose.
I'll let you have one more go at it. You say she's doing this on purpose.
Hold on.
Do you have...
Yes, I have my father, who's a witness from court one day.
What court?
Can I explain?
Don't speak.
We were in court because they tried to file an injunction for harassment, and the judge, my dad...
Just a second. Went to file an injunction against you for harassment?
Yes, ma'am. Right after I went to the police.
Just a second. And were you served with a document?
No, ma'am.
Well, then how did you end up in court?
I saw the document on my door, and unlike the defendant, I went to the court to take care of it. You can laugh all you want, but I took care of it.
You have to be served with it.
I'm actually finished. I asked one question, and you tell me that you have the answer to that question. We're going to repeat the question. Whitney's going to, and don't go off on this question. Just stick to what the question was. She said they did this thing, it's sort of either retaliation or on purpose, or...
She said that's why I'm filing defamation, because she's doing it on purpose.
On purpose. Okay, and it was the on purpose, and you said you wanted your father to testify to that and on purpose. Now go. Stand up next to your daughter. You are limited to the following. You are limited to telling me proof that you have on behalf of your daughter that the defendant has filed these charges against her, not on purpose, because she absolutely did them on purpose, but I assume that you meant maliciously.
Yes, ma'am.
Now I'll hear you.
Okay, I'm going to keep this in secret.
Maliciously. What evidence do you have that the defendant filed this complaint and swore to this complaint maliciously?
I have no proof, but...
Then you have no proof. Then you can sit down.
Right, but that's not the question she asked.
All I want to know is maliciously. Now you can sit down. Okay, now we're going to get to the last question that I have for you, and then we're done. Do you have anything in writing where she called you a drug addict?
Your Honor, in the complaint to my board.
Okay, we're done. We're done. So now we're on your case. Now we're on your counterclaim. Your counterclaim is for property damage. What property?
I will show you the documentation to the counterclaim.
Just a second. Don't tell me that you have documentation. It's a shattered window. When was the window shattered?
The window was actually shattered on August and let me make sure I get you accurate dates. I'm sorry.
Did you witness it being shattered?
No, ma'am.
If you didn't witness it being shattered, what proof do you have that if... Put your hand down.
Yes, ma'am.
Put your hand down.
I don't have it up.
Oh, put it down. Very good. Better.
We don't have witness.
If you don't have witness, then you don't have proof.
Okay.
Any other property damage? Shattered window? Anything else?
It was a broke lock. The day that she was, can I say this?
No. I'm very easy.
No, I'm saying the day that she came out and sent the police to our facility on a Saturday, the lock, I saw her leaving that day, and our lock was broken off of our gate.
All I want to know is, did anyone witness her either?
No.
Then the answer is no. Do you have any security footage of her?
I do.
Put your hand down.
She said she had.
Put your hand down.
You're going to see the video.
No.
Not the video. She stated in a document she had video of it.
Just a second.
Oh, gosh.
I don't think you understand the court process. So I'm not going to tell you. I dismissed your case, and I'm getting very close to dismissing hers. I'm dismissing those parts of her complaint which allege property damage because she has no witnesses that you, in fact, committed property damage. There's no reason for you to continue looking up papers. Your case is dismissed. Do you understand?
Yes, ma'am. It's about
very clearly. Now, the last part of this case has to do with the defendant's allegation that you, in fact, defamed her organization. I'd like to see in writing what you have to prove to me that the plaintiff defamed your organization.
Yes,
I want you to... I didn't ask you for anything. Now it's her proof. Do you understand? What I'm telling you, Miss Horn, is your behavior is a little off. I'm telling you.
Because I was framed.
Just a second. Your behavior is off. And I've told you why. I've given you specific reasons why. You had two parts of your complaint. One is for wages, which I dismissed, and the other one for calling you a drug addict, which you could not prove. No. You're not hearing me. I asked you for proof that she called you a drug addict. You didn't have it. Now, proof that she defamed your organization. May I have it, Kevin?
This is from her and her father. And
just a second. Her father isn't a party to this action.
Can I speak to the counterclaim? Because I have proof from her.
Sure.
Her text. It's her text.
This is from him. I'm not interested in anything from him. Sue him if he said nasty things to you.
Your Honor, it's just not nasty things. This all came about because of everything that Sherna has done, and she doesn't realize is that...
Listen to me.
Yes.
None of this comes from her.
She's on it. Her name is on there.
I don't care whether her name is on it. None of this comes from her. They CC'd her.
This is proof.
Put everything away. Put all your papers away. I'm not coming back to you unless I, in fact, see that there's any validity towards her counterclaim. Then I'll come back to you. Right now, your claim is dismissed. Both counts of your claim is dismissed. I've dismissed her claims for shattered window and a broken lock. And these emails do not represent any form of defamation. If you have nothing else, your claim for defamation is dismissed. Do you have anything else? The answer is yes or no.
No, Your Honor.
We're done.
Easy.
Thank you. Bye.
This court is adjourned.
Thank you.
Kimberly.
Our facility and myself have done nothing wrong.
I think I got flustered, which is fair.
We're doing everything according to the Arizona State Board and laws.
Judy and Sarah.
I actually thought that they paid her. She complained that she hadn't gotten her second paycheck. If you look at the documents.
And property damage.
Court come to order. All rise.
Have a seat, please.
Kevin.
Case 2109, Noble versus Acuna.
Thank you.
You're welcome.
Miss Noble, this is your sister.
Yes, ma'am.
Older or younger?
Younger.
Any other siblings?
Many.
How many?
I have 5 sisters and 4 brothers.
And you have kids. How many children do you have?
I have 3 daughters.
How old are they?
18, 15, and almost 12.
And you?
I have 3 children, and they are 10, 5, and 2.
There came a time when, that was in August of 2021, according to your complaint, that you were having some housing difficulties with your children.
No, that's not true.
Well, Miss Noble, what led you to believe that your sister was having some housing difficulty? Because you start your complaint by indicating that she was about to become homeless.
Her house that she was living in was being put up for sale.
So the house that you had been renting.
Correct.
For how long?
About 2 years. I'm not really sure. It was well
Was
over
being
a year.
sold.
Well, I didn't know that until I gave her my notice after I'd already previously asked my sister if we should move in.
So you approached her about you moving in with her?
Yes, correct.
And do you own your own home, Miss Noble?
I do.
Where you were living there alone with your 3 children?
Yes.
Okay, and how much rent were you paying?
$750.
Now, when you decided to move in with your sister, what rent was discussed?
Well, she had told me about $400 is what she wanted.
Okay, so she said the rent was $400 per month, and that was starting August 1st?
Right.
So this is what part of this case is about. Part of the case is about rent. You lived with your sister from August 1st, 2021 to a date in 2022 when you finally removed all of your property.
Kind of. I did not remove all of my property, but I removed what she allowed me to.
To remove on what date?
I'm going to say it was mid-May, but I'm not sure.
May of 2022.
Mm-hmm.
So we have August, September, October, November, December, January, February, March, April, May. So between 9 and 10 months. For the 9 or 10 months that you were there, how many times did you pay her $400 in rent? She's going to have a list.
I have a list too of our.
And you have a list. So why don't you take a look at it and give me the exact number of months?
The time I paid her $400 was, I think, only one time. And there was other times I paid her different amounts, but our agreement was because I bought all the groceries, we just kept track on this app, which has a list. I paid way over $400 in total.
Well.
So our agreement had changed.
Just a second.
Okay.
You have an app, 10 months.
Mm-hmm.
How much did you spend on that app?
12,000 something is right in here on the list.
Take a look, because you're going to show it to me.
I paid total $10,411.
Okay, and she?
She total was $11,291.
And that was to cover groceries, food, gas money.
Her phone was under mine.
This is something that I'm going to have to simplify. There came a time when there were issues with regard to you not paying her $400 a month rent, and you discussed it with her, correct? And in what month was that?
April.
It was before April. It was before I had gone on vacation.
What month and year?
December of 2021.
So what I'm reading in December of 2021, you had a dispute about how much you were spending, how much you weren't spending, and that $400 was not being forthcoming just for rent. You see, I can understand that the two of you decided to split bills, everything other than the $400 in rent. You each have 3 children, you're 2 adults. Let's get to December. Was it the beginning or middle of December that you had this discussion about just pay $400 a month and we'll deal with it?
Maybe the middle.
Okay, so we have January, February, March, April, and you moved out in May.
Correct. I was kicked out illegally. Yes.
In May.
Yep.
Left in May. So that's 5 months. It was suggested by your landlord that just give me $400 a month and we'll split groceries.
In April, I have the proof of the text.
Just a second. So we have January, February, March, and April. 4 months. Did you give her $400 a month for those 4 months?
Nope, it was never discussed before then. I have the proof that it was discussed in April.
I'd like to see it.
Thank you.
It was discussed in April again.
Okay, just a second. I just want to see the proof. Well, show me if you have proof of an earlier conversation.
I don't.
I believe that there was an earlier conversation. Let me see the one that occurred in April.
It was mainly the receipts.
I'm not getting involved with that at all. Right now, you had a place to live with your 3 children for much less than the $750 a month that you were paying at another residence.
Right. And I spent way more on groceries. I did all the groceries.
Whatever. Your children didn't eat more.
Right. And my children didn't live there the full time.
I don't care.
Okay. I'm sorry. Can I look on my phone? It might be faster. Is that okay if I show you the text?
I don't care where you show it to me. Just show it to me.
Thank you. I'm sorry. Oh, yeah. I apologize. Okay. Apologize. Sorry.
Tiffany hands her phone to Kevin.
On April 24th. So if you want, and then she can scroll down because she kind of keeps for a couple days.
Kevin brings the phone to Judy, who reviews it.
Oh, that wasn't an agreement, madam. These were final acts of desperation to get you to pay $400 a month. Here.
That was the first time I'd heard, about her.
Oh, no. That wasn't the first time you heard about it.
Right.
Because the first line is $400 better be under my door.
Right.
So that's not the first time you heard about it.
Right.
That's an act of desperation. Okay, so You had this conversation with her in December, and she was there until May. And according to you, you only paid $400 once. That's $2,000. By the way, how are your children supported?
I work. Well, I work, yes.
Is that a full-time job or a part-time job?
It was part-time.
Well, you don't support yourself and your 3 children with a part-time job. Do you get any child support for them?
I did get child support for 2 of them, yes.
For 2 of them?
Mm-hmm.
How much child support do you receive?
$300.
$300 a what?
A month.
Do you get any other assistance?
Yes, I had food stamps.
Mm-hmm. Do you still have food stamps?
Yes.
How much a month?
For something, I'm not exactly sure.
And when you bought food for the household, you used the food stamps as well as your other money from your part-time job, and got it, $400. So far, you owe your sister $2,000. That's for back rent. Now, you want to go through the damages that you allege that your sister caused?
Yes. So I had 2 couches, and those went away.
What do you mean both went away? What does that mean?
She got rid of them.
While she was living there?
Mm-hmm.
And you knew about it? In what month?
It was when I came back from vacation. My things were gone.
I'm not following. You were supposed to be gone for 2 weeks, according to her.
No, I was gone for 3.5 weeks.
You were gone for almost a month.
Mm-hmm.
She was babysitting for your children.
They don't really need babysat. They're older.
Well, your 12-year-old can't live by herself without a mother for a month.
No.
Okay. And your 18-year-old does what?
She works at a hotel.
So she works during the day or at night?
She didn't at the time. She was at 17 at the time.
You're not going to leave a 17, a 14, and an 11-year-old alone for a month?
Of course not.
Okay. So they were home with your sister?
Yes.
Let's get back to the initial question. I forgot what my question was before I went off on this tangent. Couches.
The couches.
That's where we're at.
Yes.
So you went away for a month, and when you came back, couches were gone.
Couches, like the whole house had transformed into basically her house.
I don't care, basically her house. I want to know what was missing.
So the couches were missing.
Okay, which couches? Couches from where to where?
So the couch from the living room, it was a sectional, and the couch from the basement.
Living room and basement. What happened to those couches?
Oh, they were gone a long time before, and I can prove you a text of her saying that they were gone before I even moved in, actually in August. She knew, and her daughter and her boyfriend helped me load them up and take them to the dump. She, in fact, told me she was getting rid of a lot of old furniture she did not care about. I have pictures.
Just a second. What you have is proof that those 2 items were disposed of before she went away on vacation.
Way before I moved in.
Okay. Now, Ms. Noble, your sister says that she has proof that those 2 couches were disposed of well before you went away on vacation. If she does, I'm not going to be happy with you. Do you understand? Mm-hmm. Were those 2 couches gone before you went on vacation?
I can't recall, but I believe she wanted to make room for her furniture.
Just a second. Were those 2 couches gone before you went on vacation for a month?
I know the basement couch wasn't.
Okay. I think you're full of baloney.
Caption, coming up.
She started giving my niece video games, movies, my food storage containers. She was just giving my things away.
Okay. I went to graduate school after I finished with high school for 9 years. I'm not dealing with Tupperware.
A courthouse. The Judy Justice logo appears. In the courtroom, Lucinda and Tiffany.
Lucinda Noble claims her sister, Tiffany Acuna, owes for rent and property damage. Tiffany is countersuing for an illegal lockout and filing a false CPS report.
Okay, let's go. Property taken without permission. What property did she take without your permission?
Okay, so
how far she owes you for rent?
The TV stand, she broke it and threw it under the trampoline.
What's next?
The weed trimmer, she took that. She started giving my niece my belongings while I was gone. She started giving my niece video games, movies, my food storage containers. She was just giving my things away.
Okay, she owes you for rent. I went to graduate school after I finished with high school for 9 years. I'm not dealing with Tupperware. So far, she owes you $2,000 for rent.
Okay, and then there was also the wall damage, the windows, the blinds,
just
the
a second. Just a second. What wall damage and where?
The wall damage is from the room that she was staying in and the room that her boys were staying in.
May I see the damage that you're referring to?
Lucinda produces photos, then hands them to Kevin.
Here's the one more of that, and then here's the blinds. And this was damages from her cat.
Kevin brings the photos to Judy, who reviews them.
Well, this I can't see at all. Okay, so that I can't see at all. And if you're talking about nail holes, I'm not interested in nail holes where there were pictures, putty them up. I don't know what this is a picture of. Tell me.
That's where her cat clawed up the carpet to get into her room.
Did you replace the carpet?
Not yet.
Do you have an estimate for replacing or patching that carpet?
They don't make that carpet anymore.
Okay, I don't know that. How did these blinds get broken?
I'm not sure. Are those the ones that were in my bedroom or the kids' bedroom? I really don't know, to be honest. But I do feel like I remember them being broken, but I just don't remember if they were broken when I already moved in or not. I really don't know, ma'am. I mean, honestly, I knew they were broken. It's like I'm remembering, but the house, like I said, was not in a good condition when I moved in.
Okay, I'm not talking about the rest of the house.
My daughter is actually, Tiffany told her that she knew they were.
She doesn't remember. You tell me that these blinds were in good condition before she and her family moved in.
Yes.
She says she doesn't remember. I have to rely on what you say to me because that's not ordinary wear and tear.
No.
Do you have a bill for new blinds?
From Lowe's, I have the estimate of what it will cost to replace them.
Okay, I'd like to see it.
Lucinda hands a document to Kevin.
You do have a cat?
Yes, I have one cat.
Okay.
She has multiple.
Kevin hands the document to Judy, who reviews it.
So we're talking about $47.98.
Times 2.
Okay. Anything else? Any other?
For 2 blinds.
I only see one.
No, those are 2 different windows.
Oh, times 2. You're right. Anything else?
I have to remove the junk that she left at my house.
I was not allowed at her house.
What else?
That's...
Okay, if you have to think that hard, then we're finished. We're moving over to the countersuit. Okay. Counterclaim is for an illegal lockout. Okay, let me run through this illegal lockout and dispose of it quickly. The illegal lockout that you're referring to happened when your sister, who shouldn't have, took the door off your bedroom.
Correct.
She says she took the door off your bedroom because you weren't paying close enough attention to your children.
Correct.
And I assume she's talking about the 2-year-old.
Correct.
And when she took the door off your bedroom, you called the police.
Right, yep. I called the police. I have the incident report.
Yes, you called the police, and the police came, and when the police came on, do we have the date?
26th April.
The police arrived, and they told her she couldn't lock the door, and you were let in.
Correct.
Okay, so not egregious enough for me to have to deal with 2 sisters fighting. But the other part of your claim is that your sister filed a false CPS report.
Right.
And first, how do you know a CPS report was called in?
Well, they called me. Real quick.
Child Protective Services.
Right, they did call me, but first I actually had the phone call from my sister, my witness, who is here right now, because she had pre-warned me because she had gotten the phone call from this sister saying, Lucy is going to call on you.
Okay. Do you want to step up?
Sure.
Tell me your name.
My name's Stephanie Aslett. I'm the older sister from these 2. Yeah.
When did you have a conversation with Miss Noble about the defendant's children?
The same night that the cops were called. Tiffany had called me because Lucy's daughter had crawled through the window and opened the door.
So you spoke to Lucinda?
Yes.
On April 26th?
Yes.
Did you call her or did she call you?
She had called me because she wanted to let me know that the cops had been
Do you recall that conversation?
Yes, I do.
Okay, tell me about the conversation.
She called to let me know that she was letting me know that since I was the only one probably capable or in this position to take on a child if CPS was involved, because the 2-year-old would not be able to go to his father. He was in prison at the time. And I was like, why are you calling and telling me this? Tiffany's a good mom. What's going on? And she goes, no, she's not. I've already called CPS and forewarned them that this is happening. She needs to be taken care of.
What's happening?
Apparently there was lice on her daughter when she was at her father's house, and the 2-year-old, apparently he was running around with a wet diaper.
Who was taken to their father's house?
The daughter that had the lice was,
The daughter was the 5-year-old?
Yes. And
Okay, not the
lice
2-year-old.
Yeah, she supposedly had lice while she was at her dad's.
Went to her father's, and that was sometime in April. Is that correct?
Yes.
And got head lice.
Well, he had told me, I wasn't for sure, but I'd let my sister know just in case that she may have lice. Let's check the girls.
Okay. And your sister was home at the time?
Well, no, she was never home. Everything was over text message because.
Just a second. Was that when she was away?
She was not staying at the house. She was not at the residence. She was staying at her boyfriend's house that was there.
Lucinda was staying at her
Yes.
boyfriend's house?
Yes.
Okay. And that's on the 26th?
Yes.
Is that after the police were called?
That was prior to, supposedly the lice was prior to, and that's why she had called them prior to that night. And she was letting me know that she had called them and that I needed to be prepared to take on a 2-year-old.
What did you tell her?
I asked her why she would call them, what was going on, and I said, this is ridiculous. You know that this is ridiculous? And she goes, no, it's justified. And I said, I don't understand.
Did she tell you why?
Yeah, she tried to tell me that.
Well, tell me exactly what she said to you. Why is this
She made
justified?
the comment that
so she called
Tiffany has
you.
not been there.
Okay, you had to ask
My
her
words
why.
to her were, how do you know this when you're never there?
And she said?
I just know.
And gave you no more specifics?
No.
Okay, you want to tell me about that conversation?
I never said I was calling CPS. I said someone will. I know the person who did. It wasn't me.
Okay, well.
But I knew it was going to be happening.
Okay, Stephanie, let's get clear, okay? When you spoke to Lucinda and she said to you, in effect, are you prepared to take on a 2-year-old? Did she tell you that someone was calling CPS?
No, she did not. She said that she would be the one calling and that she has already contacted them because of the situation at her home.
Okay, now, assuming you and your sister lived alone together, whether you spent time with your boyfriend, I know you have older kids, but you were away. When you were away for that month, were you staying with your boyfriend?
Yes.
Okay, and you left your kids alone, correct?
With my sister.
With your sister. Now, why would you feel comfortable about leaving your own children with your sister if you felt that she neglected her own children?
They didn't need the amount of care that a 2-year-old does.
Are you telling me that a 15-year-old doesn't need a lot of care and watching these days? Or a 12-year-old or an 11-year-old doesn't need a lot of watching and supervising? Is that what you're suggesting to me?
Not as much as a 2-year-old.
Well, one is a physical watching to make sure that it eats and drinks and is bathed periodically. The other two are far more difficult. You got to have eyes all over the place to watch a 15-year-old and an 11-year-old. Got to have your eyes on their computer. You have to have your eyes on their iPad. You have to have your eyes on their schooling, on their homework, on their everything else. You take a month to go off with your boyfriend. That, to me, is not participating with your children, especially since you suggest that your sister, with whom you left your children, was neglecting her own children.
Your Honor, I would just like to say that I was reaching out to her a lot of the time, too, where I would get 1 week, there was nothing. She said, I'm sorry, I had no Wi-Fi. Her children were skipping school. They were not listening to me. They would not do their work.
Do I need you to reinforce what I just said?
Right.
I don't need you to reinforce what I just said.
Caption coming up.
You had had a history with methamphetamines. You refused to meet with caseworkers, according to the report you gave me.
I have other reports, too, if I may, please.
Thank you. I'm not finished.
A courthouse. The Judy Justice logo appears. In the courtroom, Lucinda and Tiffany.
Lucinda Noble is accusing her sister, Tiffany Acuna, of refusing to pay for rent. Tiffany claims Lucinda wrongfully reported her to Child Protective Services.
Now, you have something you want to say?
Many things, actually.
Well, many things. I don't want many things. What I want, stand up. What I want to know is you're her daughter.
Yes.
Your first name?
Anna Noble.
Anna, what do you do?
I work front desk at a hotel.
Graduate from high school?
No.
Why?
I was pulled out and moved to Missouri.
Pulled out by whom? By your mother?
Yeah.
And when your mother pulled you out, how old were you?
17.
Had you been going to school before?
Yes.
In what jurisdiction?
It was an alternative school.
When you say an alternative school, what kind of an alternative school?
For troubled youth.
Tell me about your trouble. Was it behavior trouble? Because
It
you
was
seem
many things. I was a very wild teenager.
Until when were you a wild teenager?
Until I sent her to live with her dad.
I didn't ask you any questions. So now you can sit down.
Okay.
I'm not going into anything else. Lucinda, so far you went away for a month with your boyfriend, leaving your 3 children, who you say don't need supervision. How long were you home before you took the door off her bedroom?
I got back from vacation in February, early February, and the door was removed in April for a few hours.
Okay. Do you have any proof other than this conversation that the plaintiff called CPS?
I believe it is proof, just the thing that was reported is something she would only know. Would that be considered proof?
Well,
okay.
Let me hear what was reported.
It was reported that I would not treat my child with lice. That was what the CPS report was, and it was unsubstantiated, and I have that all proof.
Okay. When your 5-year-old went to her father, she went to visit with her father, and children do get head lice. It happens periodically. Lots of children who go to school, who interact with other children, come home and they get head lice. I've had a lot of children, a lot of grandchildren, and it happens. And you usually treat it. I assume that her father did not treat it. Is that right?
He did treat it. He told me. He told me immediately.
So he treated it. So how do you know that the head lice was the nature of the complaint?
That's what was on the report.
May I see it? Your children weren't removed, except for your boy.
My one son, and then that lady.
And then returned.
All 3.
Oh, yeah.
All 3 kids were taken.
That's it.
Okay. There you go, sir.
Tiffany hands a document to Kevin, who brings it to Judy. She reviews it.
Okay, you had a prior history with Child Protective Services.
Which I was unaware.
That's either a yes or a no.
Yep, yes.
And during the course of those prior proceedings, which were relatively current Child Protective proceedings, because that was in 2021, you were clearly drug tested by the Department of Social Services or Child Protective Services.
In 2018 or 19. This was at my doctor's prior when I was, and they reported it that I had failed one of my
And
tests.
at that time, you had an open case and you tested positive for serious drugs.
Right.
Very serious drugs. And this says that while under the influence of those drugs, you drove your children to the doctor's office while under the influence.
Right.
That's the report.
Right.
Okay. These reports all seem to indicate that they tried to see you, but you kept canceling appointments with them and were a no-show.
Well,
okay, that's what this report says. You gave me the report.
Right.
So let me understand this. After coming in and making an assessment, Child Protective Services determined to file a petition on behalf of your youngest child. Yes, they did.
Okay, yeah.
Well, after everything I read there, I think that that was probably a good idea. I don't know what happened with that. I assume that the petition was ultimately dismissed if you have your children back with you.
Right
Do
away.
you have your children back with you?
Yeah, right away, as soon as I went to court that day.
That's okay. They determined, after they spoke to you, and irrespective of either her motivation or anybody acting on her behalf, or somebody that she knew, or her, called Child Protective Services. The question that I'm presented with, was there a basis for concern about your children?
No.
And based upon the reports that I've read here, and those are reports that you gave me, that those serious questions about what was going on with the young children in your house deserved a second look. You had had a history with methamphetamines. You had a serious weight loss. You refused to meet with caseworkers, according to the report you gave me.
I have other reports too, if I may, please.
Thank
you.
I'm not finished.
Okay, good. Thank you.
Because if you've been in family court, as I was for 25 years, often incidents are called in of suspected child abuse and neglect. A caseworker goes out, takes a look, and says, you know, I'll continue to watch it, but I don't have to file a case. It hasn't reached the level where I think that I should file a case and remove a child. In this case, Child Protective Services came and tried to do an investigation, which, according to the worker, you evaded. You missed appointments, you rescheduled, you didn't show up.
One time.
And then, not one time, they also had a prior history of you involving drugs, involving driving your children under the influence of drugs. Recent history, didn't happen 20 years ago. If it happened 2019, this says 21. If it happened 2019 or 2020, that's still recent history. So whoever called, it was worth, according to this caseworker, they had sufficient information based upon what they saw and what they knew to remove the 2-year-old. So that part of your case is dismissed, which is the only part of your counterclaim that I was really entertaining. You owe your sister $2,096, $2,000 for rent and $48 for, I forget what it was, blinds. Thank you, we're done.
My
This court is
property,
adjourned.
We're done.
Tiffany.
I had drug tested every month during the time that this happened, and it was like a oopsie under my doctor's supervision.
I just helped her, and she takes advantage and takes advantage.
You don't call CPS on your sister when you're the one that took off to Africa for 3 weeks, 4 weeks.
And this whole thing wasn't about money. It just, I needed someone to tell her, look, you can't take advantage of people anymore.
She's still the outcast that everyone's upset with.
I'm not the outcast, though, but I'm definitely not helping her anymore.
Sarah and Judy.
So we've seen it a lot here, claims for unsubstantiated CPS reports being filed and people seeking damages for that. So I'm just wondering, do you think there was a basis? Is that why, obviously, you didn't rule in her favor on the claim of the false CPS report? So there must have been something in there that...
You know, when people use Child Protective Services as a retaliation for other behavior, that's always abhorrent. But there are some situations where CPS may be called because someone knows that there is an abuse or neglect and has not done it until the other person irritates them. Well, that's not a false CPS report. Maybe motivated by something else, but that's not a false report. And so, in this case, the defendant had a history with CPS. Current history with CPS that was relatively serious. Well, then it was a good thing that CPS went.
Because that would be basis itself.
It's
for
basis
the claim.
itself, yeah, basis itself.
That alone. And just because she was cleared at the end of the day and has her children back now doesn't mean that it was an unsubstantiated claim.
Oh, no, they're watching.
Yeah.
They're watching, and they should be watching. I don't think any of them are bargains. The 18-year-old daughter.
for vandalism after his 16-year-old son damaged her car.
Court come to order. All rise.
Judge Judy.
Have a seat, everyone.
Kevin.
Hello, Judge. Case 2101, Lawson versus Baumgartner.
Thank you.
Welcome.
Ms. Larson, it is your claim that the defendant's son, I assume that's this young man over here, vandalized your car. And he vandalized your car by smashing in a side mirror.
Yes, ma'am.
Which required you to be without a car for a day while they fixed it. So you want his father, who was actually present at the time, to pay for the damage.
Yes, ma'am.
From what I gather, this happened on Father's Day, which was June 19th
Yes.
of this year, and you were going over to visit your father
Yes.
for Father's Day. Stand up.
Chris's son rises.
What I gather from your complaint, was he sleeping?
Yes, he was.
Okay. Some sort of an altercation happened, which you'll tell me about in a moment. His father was called.
Yes, ma'am.
His father came. This kerfuffle continued, and when they were on their way out, this young man, whose name is?
Caden Baumgartner?
Caden.
Caden.
Caden smashed in your passenger mirror, and his father says, well, he actually saw him do that, but it was just pushing in the window, the mirror, and really all you had to do was pull it out, and it would have been fine.
Right.
That's your defense?
Yes, ma'am.
Okay. So let's start out when you arrived at your father's house. What time?
I arrived at my father's about, I would say, about 11:15.
Okay. What happened?
And it woke up Caden in the process. Caden got upset.
What did he say? How did you know he was upset?
He started screaming and pretty much saying, why the heck are you coming in here, waking everybody up? You have no right to.
Okay.
And then after that, Caden got up and started yelling, started punching the walls, screaming. My father went in there, and then his father, Chris, ended up getting called to come get Caden.
How far do you live from where Miss Larson's father lives?
About 7 miles away.
How old is your son?
He's 16.
Is he the oldest one of your children, in the middle?
The youngest.
Any other children at home other than him?
No, ma'am.
So he's the baby and he's home?
Yes.
Who sets the rules for him?
Well, I do.
Where did you think he was going?
No, I knew he was over they had something to do for Mother's Day, and then they
That was Father's Day.
Well, I know, but I'm saying for the entire
Well, Mother's Day is in May, Father's Day is in June.
But they
usually don't have carryovers.
Something planned, I don't know. But anyhow, yeah, he was over there.
Times have changed, life has changed. The only time you got to sleep outside your house when I was growing up was when you were outside in a pine box or a white dress. That was it. Those were your choices.
Yes, ma'am.
That's the way you could leave your parents' house, right? I chose the dress. All right. Now, Caden, I'm going to come around to you because, you know, we're not talking about somebody losing 2 pints of blood or somebody losing a finger.
Yeah.
I know what it's like to wake up a teenager at 11:30 in the morning.
Mm-hmm.
I'm usually ready for dinner at 11:30 in the morning. But teenagers, you know, they're still growing, so they sleep late. But you were particularly annoyed when Miss Larson came in, right?
Yes.
Why?
Well, she did put it the right way, but she didn't put it the right way because.
But just to tell me why.
Well,
Don't look at her. Talk
She
to me.
didn't just wake her up. She came in there loud.
When she walked in, Caden, to a room in her father's house, what did she say? And tell me in what tone of voice she said it.
She said in like a excited voice, but not like a mad voice, excited voice.
All right, and that got you mad.
No, that's not what got me mad. I didn't
What got you mad?
By the time I could even finish my sentence, she's already busted in through the door and was in my face saying, you got something to say to me.
Just a second. You're not following me. She came in, and the first thing you said was she was talking too loud, and I want to know what you said to her.
I didn't say nothing to her.
Nothing.
Nothing. I didn't even
Nothing.
look at her.
And then she left, so...
She cussed at me, but then she walked in there and she later said...
Who cussed at you?
Her. And then she later said
Well,
that
just
she
a
was
second. I didn't get to that part, that she cussed at you. If you didn't say anything to her, what would she cuss at you?
Because she got a phone call from her saying that she wants me to get ran out of the house. That's how this all started.
Just a second. Oh, that's a different story. Okay, so what you're saying to me is you believe that she came over for the purpose of getting you out of the house.
I believe so, yes. Because that's what I got told.
Well, let us assume for a moment that's true. That would sound right to me. Get him out of the house. It's 11:30 in the morning on Father's Day. We want to have a party here. Get him out of the house. That would sound right on the money to moi. Right on the money. I mean, if that's what it was about. So I don't care if that's what it was about or not. Okay. Your father comes. What happened when you got there, sir?
When I showed up, I went to the door, I knocked on it, they answered the door, it was pretty chaotic.
Look at me.
It was pretty chaotic.
Describe what chaotic is.
Okay, there was a bunch of yelling and screaming going on between Kate and my son and the plaintiff.
And Miss Larson.
Miss Larson, yes. And I told my son, I said, hey, you just need to step outside and let me figure out what's going on here, and I'll be right out. I tried to talk to Mark. Mark come out of the room.
Who's Mark?
That's the father. He was being very disrespectful, he said, and he said he wanted him to leave. I said, okay, that's no problem, I'll get him
Just
out
a
of here.
second. The father came out of the room and said, I want Caden to leave.
Right.
And did he leave?
When I come and got him, we left, yes, we did.
And he walked out the front door.
Yes, he did.
And when he walked out the front door, he passed the plaintiff's car.
Yes, I believe so.
What do you mean? You wrote it in your answer, sir.
Yes, I
so
did.
the answer
Yes,
is
I did.
yes.
Yes.
And you saw him do what to the mirror?
Caption coming up.
Don't minimize what he did. I would have slapped him upside the head if I saw him take his hand and knock off somebody's mirror. I really didn't mean that. I don't believe in corporal punishment.
Amen.
And later today.
What do you think that I think of a person who says, okay, I'll go with you to this very, very sad time? Someone who I've been close and intimate with for months, but it's going to cost you $900.
A courthouse. The Judy Justice logo appears. In the courtroom, Morgan, Chris, and Caden.
Morgan Larson claims Chris Bumgardner's 16-year-old son, Caden, vandalized her car.
Now, you saw him do what to the mirror?
Push it in.
Okay, very good. Now, do you have photographs of the pushed-in mirror?
I do.
I'd like to see it.
Okay, one moment.
Just for my own curiosity, you knew that it was wrong for him to touch that mirror.
Yes, ma'am.
Okay, and if what you say is he just pushed the mirror in and all it had to do was be, you believe, to be clicked out?
I believe to be
just,
clicked out.
Why didn't you do that? Why didn't you say to him, don't touch somebody else's property? That's what this is all about.
Well, I
Your
believe
temper.
I did say that to him.
Just
I
a
said,
second.
Don't put your hand.
Well, then why didn't you pull out the mirror if that's all it was? If you say the only thing
because
wrong
she
with the
was
mirror is
coming
that it has to be pulled out, why didn't you do that? You didn't see him touch the mirror.
No, I did not.
You were there.
She was right behind us.
She didn't see it. You saw it. So my only question to you is, if you saw it and it was that minor thing, and you know what it is, either you can click the mirror in and then you pull it out. I'm always afraid to click it out that I'm going to break it.
Exactly.
You're not suggesting that anybody else touched this mirror to damage it. No. Okay, let's see.
Kevin brings photos to Judy, who reviews them.
What did he use on the mirror, sir? What did he use to hit the mirror?
I believe it was his hand.
When you say you believe it was his hand, did you see what was in his hand?
He had nothing in his hand.
Did his hand get bloody?
No.
Okay, Kevin, would you turn these over to the defendant, please, and get from the plaintiff an estimate for the damage?
Kevin shows the photos to Chris.
That's not what...
Well, they ripped it off there.
Well, yeah, clearly, because that's not what it looked like when I seen. Because when he walked by, he just simply, okay. And I said, now, Caden, that's enough.
Chris returns the photos to Kevin, who brings them to Judy.
So you had a $500 deductible on your insurance?
Yes, I did.
And you had it fixed?
Yes, I did.
Okay. And you paid $442.74. Good. How long did it take them to fix it?
I would say about a month with the parts being on back order. And I
but you had the use of the car all that time?
No.
Oh, of course you did. Okay. Just want to see what you have for a car rental.
Your Honor, I don't understand this car rental part of it. I've been without a mirror before.
Sir, you're not allowed to drive without two mirrors.
Then there was one in the cab as well. That's two mirrors, isn't it?
I don't know what you're asking me, sir, because at some point you just have to take the car, and let's say it takes a day once you get the parts. At some point you have to take the car in and you're without a car for a day. Well, then you can either be without a car for a day or you can rent a car for a day. I'm not giving her a rental for a month. I'm not crazy. You know, there's a certain amount of inconvenience that one endures when somebody else vandalizes a piece of their property. And that's part of the punishment.
Well, I understand.
Yeah, I'm glad you understand. Don't minimize what he did. I would have slapped him upside the head if I saw him take his hand and knock off somebody's mirror. I really didn't mean that. I don't believe in corporal punishment.
Amen.
I don't think you needed 15 days to fix this.
I didn't think so either.
Well, I certainly don't think so. But you're entitled to a day's car rent. So I put that down as $200, including everything, $642.74. Judgment for the plaintiff. Thank you very much.
This court is adjourned.
Chris, then Morgan.
I didn't think that I needed to pay the whole $1,300 out of pocket.
I'm just glad someone finally held them accountable for what they did.
The mirror, I was walking past it and just hit it. Bam, you know what I mean?
I finally am getting reimbursed for the money I had to pay.
I knew what I was doing, and when I did it, I did regret it after I did it, you know what I mean?
I feel like some people need to control their children better.
Judy and Sarah.
It's also a sign of the times that this father did not own up to what he saw.
I will say he was on the more responsible side of parents than some that we've seen here. He said, I said, Caden, what are you doing? This is not how you act. This is not how you behave. So that I almost appreciated. But he didn't take it as far as you or I would have liked.
As far as knock at the door. I know this is hot. My son did something wrong. I'm going to pay for it.
Yep.
Whatever it is. I have to come into the 21st century kicking and screaming.
I'll try and help you as much as I can.
Thanks.
Kevin.
Case 2105, Davey versus Miller. All parties, please step forward.
Melissa Davey is suing her ex-boyfriend, Joseph Miller, for an unpaid loan.
Mr. Miller, I think I'm going to start with you today, just because I have to kind of shake it up for myself. Otherwise, I get stale. You and Miss Davey were sort of in a relationship for a brief period of time.
Yes, Judge.
Never lived together.
No.
There came a time when you wanted a new car. Not a new car, but a better car.
Yes.
You wanted a better car because you wanted to use that car as a driver for Uber.
Yes.
And you needed a down payment.
Yes.
And according to what I've read from Miss Davey, and what you seem to acknowledge in your answer, Miss Davey loaned you $1,200.
That is correct.
Things didn't work out, which happens. You paid her back $300.
Yes.
Did not pay her back $900.
Correct.
So that would make it easy, except that you have a defense.
Correct.
And I'm going to let you tell me and the rest of the world what that defense is and show the world what a prince of a guy you are.
I hope I can do that.
You're no longer together.
Correct.
You owe her $900.
No.
Well, you just acknowledged that you paid her $3 and you owed $9 because she gave you $12.
I owed $9.
I said at that point you owed $9. You're no longer together.
Yeah, I'm sorry. I misheard you then.
Okay. Well, I sympathize with that because I do a lot of mishearing myself. But what I said to you was, at the time you broke up, you owed her $900.
That is correct.
Now you're going to pick it up from there and tell me and the rest of the world what your defense is. Because I read it. I just want to hear it from you.
All right. At the time of our breakup, you are correct. I did owe Miss Davies $900 and had told her that I would continue to pay on the debt that was owed.
Okay, and what was the month and year of your breakup?
End of April, maybe?
End of May.
End of May?
May.
Okay, end of May, broke up, owing $900. And you said?
I tried to be cordial and have conversations periodically with Miss Davies, and they did not go well. And then Miss Davies had to put her...
No. You tried to have conversations with her with a view towards what?
Just to reassure her that I was going to pay her back the rest of the money.
Okay, so she would call you and say, where's my money?
No, I would send her a text and kind of chat, and then I would give her a quick call and say hello, and we would have just a little chat every now and then, just to remind her that, hey, I will pay you back the money.
That sounds so off, Mr. Miller. People don't usually call an ex-girlfriend who they owe $900 to and say, hey, by the way, I know I'm going to pay you back the money. I just need a little time. That usually comes from the other side contacting them and saying, I would like my money.
Typically, you are correct that most people, if you owe the money, you don't contact the person that is owed the money. I didn't want her to do that. I didn't want to have her come to me and be like, hey, where is my money?
Okay, so you break up the end of May. Did you give her any money in June?
I gave her one in April and one in July of $154.
So at the time that you broke up, you had only given her $150.
Correct.
Later on, she kept bothering you. You were reassuring her. And in July, you gave her another $150.
Correct.
Keep going. I still get $900.
Caption coming up.
Where does it say she's forgiven your debt?
The very top one, I believe it says you won't have to pay for a thing.
No.
And that was...
No. Miller, this doesn't say she's forgiven your debt.
Melissa grins. A courthouse. The Judy Justice logo appears. In the courtroom, Melissa and Joseph.
Melissa Davy claims her ex-boyfriend, Joseph Miller, owes for an unpaid loan.
I still get $900.
In July, she had to put her dog down. And
that was in mid-July?
I believe, yeah, about the...
July 11th.
So you'd already given her the other 150.
Yeah, and...
So she called you and said...
She sent me a message that said, hey, you know, I'm gonna do this. So I called and she's like, hey, I'd really, really like you there.
I can't, the last couple of words you just sort of muttered, sir. I don't know why you sort of muttered them. She called you and said...
I would really love to have you there. I don't want to do this alone. I would really appreciate if you would come.
Okay, and did you think of that as a reasonable request?
Yes and no.
Okay, did you agree to go?
After we talked...
No. I want you to tell me what she said and what you said.
She said that she would do anything.
No. I really want you to go. And this is on the phone. That's what you told me. This was on the phone.
Yes.
So you didn't say that she could see on the phone. She said, I'd really like you to go. And you said what?
I think that could be worked out.
Okay. I think that could be worked out.
Yes.
And then what's the next thing that was said, and by whom?
I believe she said that I would do anything to have you there. I don't want to do this alone.
Well, you told me that before. After she said, I really don't want to do this alone. I would really like you to be there with me.
And I said...
And you said, that could be... What did he say?
He said, okay, I think that could be worked out.
I think that could be worked out. Okay, so that's what you said. And then who said something after that?
She said that she would do
She already said she would do anything?
Yeah, she would even relieve my debt.
She said that, or did you?
She said that.
She said it?
Yes.
Okay, because that's what his answer was here. Okay. And so then you said to her, fine, I'll go with you. And you went with her, and you spent 3-4 hours there while the unfortunate business of an end of life for a beloved pet takes place. And prince that you are, you relieved yourself of the $900 that you owed her.
Yes.
Just for my own information, how long did you and Miss Davy date or have a relationship? A month, 2 months, 3 months?
4 months.
4 months. Did you get close?
Tried.
Both of you, or just she?
Both.
So you tried to make it a warm, close, intimate relationship.
As best we could, yes.
And when you needed some help, she offered to help you.
Correct.
What do you think that I think of a person who understands the word close, warm, affectionate? What do you think that I think of a person who says, okay, I'll go with you through this very, very sad time? Someone who I've been close and intimate with for months, so I'm going to spend a couple of hours in the afternoon with you at this very tough time, but it's going to cost you $900, which is in effect exactly what you said, but it's going to cost you $900. Let us assume that I believe you, a reasonable ex-boyfriend who wanted to be, as you said, I didn't want her to have to come and chase me. I wanted to assure her. So a reasonable ex-boyfriend would say, sure, I'll keep you company.
In theory, yes. There were circumstances when Miss Davies and I broke up that were not the best for either of us. And it wasn't a cordial breakup. It was very rocky. At the time when she called and asked me to come, I didn't want to speak to her at all.
I would have respected that, sir. You say, this was very rocky, it was nasty, we don't really like each other anymore, or I don't like you anymore. I don't know how she feels about you, and it's really not something that I want to do. I don't want to be involved with that. I could actually understand that if it was acrimonious, as you say. What I can't understand is somebody saying, I'll go with you, but it's going to cost you $900. That's what I don't understand.
Well, she brought that up. She was the one that stated that she would relieve the debt. And I was like, okay, whatever. So
okay, Miss Davy, now it's up to you. Now I have been grilling Mr. Miller. So I have only one question to you. Do you remember the conversation when you discussed with him going with you to the vet?
Yes, I have it in text.
I'd like to see it.
Judge,
Speak not.
Okay.
Unless you have the text messages.
This is the date I called to make the vet appointment.
Kevin brings Melissa's phone to Judy, who examines it.
Sarah, can you tell me what dates these are?
Sure. If you go out, these were all Saturday, July 9th, and if you pull over, you can see the time.
Judy continues to examine the phone.
Well, I'm looking at all these, and I don't see anything about her saying to you, if you come with me, I'll forgive your debt. So if you have one of those, I'll take a look at it.
The very top one. That was after a phone conversation with Miss Davis?
Just a second. Where does it say she's forgiven your debt?
The very top one, I believe it says you won't have to pay for a thing.
No.
And that was...
No. Miller, you know what I'm talking about, sir. She tells you to keep your gas receipts. So if you're coming to help her, it's not going to cost you anything out of pocket. This doesn't say she's forgiven your debt. You have family, you have siblings, parents, anything?
Yes.
Yeah, well, they're going to be disappointed in you, Mr. Miller, because it's not princely activity. It was clear to me from reading the plaintiff's notes to you that at least it appeared that she was struggling more with the end of your relationship than you were. That's just what it appears. And I'm a pretty good judge of that. And you sound like an intelligent man, soulless, but yet intelligent. So if you have any emotion whatsoever, you can look at this and say, this is a lady who's sort of struggling. Let me see how I can take advantage of that. I owe her $900. And I'm going to figure out that if I do this for her and it's really important, I shouldn't have to pay her back the $900. Unprincely, Mr. Miller. Judgment for the plaintiff in the amount of $900. We're finished here.
This court is adjourned.
Outside the courtroom, Joseph and Melissa.
People just sometimes don't agree.
It was very clear cut.
At the time, I was very upset with her.
I think he tried his best to just keep things cordial.
Move on and move forward.
Another wonderful relationship that's hopefully will not end up in court.
Sarah and Judy.
It intrigues me how men can make the jump from keep your gas receipts to you don't have to pay me your $900 debt. We read the messages and we were unclear as to what debt forgiveness in the messages. We didn't see it. He handed us the exact same text that we had read on her phone. He said, yeah, that's what that means.
I think he knew what it meant, because if you checked out his smirk when he handed me just that one piece of paper, he knew that when he says, keep your gas receipts, I don't want it to cost you anything to come with her to the vet. Having
3, 2, 1, go. Well done. Three, 2, 1, go. Three, 2, 1, go. Well done.